Good afternoon. The committee will come to order. Without objection, the chair is authorized to declare a recess at any time. Before we proceed with our hearing, we have a housekeeping matter to take care of regarding the appointment of members to our subcommittees. My understanding is that the assignments of the subcommittees are satisfactory to all. Therefore, without objection, the following members are appointed to serve on the Subcommittee on Rules and Organization of the House. For Republicans, Ms. Fishbach is chair. In addition to Ms. Fishbach, Mr. Scott, Mr. Griffith, and Mr. Jack. For Democrats, Ms. Scanlon as ranking member and Mr. McGovern. For the Subcommittee on Legislative and Budget Process, the following members are appointed. For Republicans, Mr. Langworthy is chair, in addition to Mr. Norman, Mr. Roy, and Mrs. Houchin. For Democrats, Ms. Ledger-Fernandez is ranking member, and Mr. Neguse. Hearing no further comments, we'll now proceed with our hearing. Today, the Rules Committee is convening to consider 4 separate measures: H.R. 22, H.R. 1526, S.J. Res. 18, S.J. Res. 28. H.R. 22, the Safeguard American Voter Eligibility Act, or SAVE Act, would amend the National Voter Registration Act of 1993 to require proof of U.S. citizenship to register an individual to vote in elections for federal office. The only people who should vote in American elections are American citizens. There's no debate about it. Republicans do not thumb our noses at election integrity, for we understand that Americans deserve free, transparent, and fair elections. The SAVE Act presents us with an opportunity to add additional layers of protection to elections right here in our own country. It's an opportunity worthy of bipartisan support. In 1526, the No Rogue Rulings Act of 2025 would limit the authority of district courts to provide sweeping injunctive relief on a nationwide or exceedingly broad scale. As of late, we have certainly seen a slew of rulings by rogue judges that surpass their own constitutional authority. This is judicial warfare in the flesh. If it is not remedied in a common sense and expeditious fashion, these exercises in partisanship will do further irreparable damage to the nation and to the confidence of Americans in our own justice system. Without question, exceeding constitutional mandates as a matter of judicial philosophy does nothing more than blight justice itself. S.J. Res. 18, a Congressional Review Act resolution, would overturn a midnight rule issued by Consumer Financial Protection Bureau, CFPB, that undercuts the ability of lower-income Americans to access liquidity. To put it simply, the CFPB's own rule hurts the very consumers that it purports to protect. This rule mandates that extensions of overdraft credit offered by very large financial institutions adhere to consumer protections required of similarly situated products unless the overdraft fee is at or below the institution's costs and losses. One of the likely outcomes of this rule being fully implemented would be low-income Americans being expelled from the financial system entirely due to a lack of overdraft protection. It's time to add this midnight rule to the burn pile. S.J. Res. 28, another Congressional Review Act resolution, would overturn another CFPB rule that unjustly shackles private sector companies that operate within the digital asset marketplace. There's no legitimate basis for this rule. It's purely an exercise in exerting more government control. This rule is billed as a consumer protection mechanism, but what it really does is misclassify an entire segment of digital products with the aim of regulating them straight into the ground. The CFPB overstepped its regulatory authority in its pursuit of subjugating the American economy in the name of, quote, consumer protection, end quote. This is yet another misguided rule that we'll rightly repeal. With that, I look forward to today's discussion. I now yield to the ranking member, Mr. McGovern, for any comments he wishes to make.
Well, thank you, Madam Chair. And let's not beat around the bush, and let me say this as clearly as possible. This administration is already a complete and total disaster. We've heard for years from the other side about the importance of safeguarding classified information and the need to use secure channels. And last week we found out that Trump's entire national security team is just casually planning military operations on unsecured group threads that anyone could have access to. In fact, the Pentagon said Signal, the app they used, is vulnerable to hacking by our adversaries. Defense Secretary Pete Hegseth, our Vice President, and the President's Chief of Staff, our CIA and NSA directors, all of them swapping classified battle plans like school kids sending memes. This is nuts. I mean, based on public comments, one of the participants in Signalgate had the text going to his unattended personal phone back at home because he was in Moscow. I mean, you can't make this stuff up. And let me just lay out for people, this isn't just stupid, it's dangerous. 30 minutes before planes took off, our top government officials were putting out onto the internet details about their mission. Who was listening? We have no idea. Russia was probably listening. China was probably listening. Iran was listening. I'm sure tapping unsecured phones of our national security advisors is one of their top priorities. Doing this might have given our enemies a chance to position anti-aircraft resources or given a heads up to the targets that they should leave where they are because U.S. planes are on the way. They put the entire mission in jeopardy, and they put the lives of our troops in danger. We also know that apparently this wasn't the first time classified information was sent via unofficial channels. The Wall Street Journal is reporting that National Security Advisor Mike Waltz created and hosted several other sensitive national security conversations on Signal, including separate threads on how to broker peace between Russia and Ukraine. I mean, this is ridiculous. This is not a game, and there's still so much that we don't know. We need a full investigation to understand the scope of damage done and if there are other national security communications happening on unsecured channels. Those responsible must be held accountable, and Hegseth should resign immediately. But while this administration is busy putting our troops at risk, while our economy is crumbling because of Trump's erratic obsession with tariffs, while students are literally getting kidnapped off our streets by masked ICE agents because they wrote an op-ed that Donald Trump didn't agree with, what are my Republican colleagues doing? Are they focused on fixing things or making Americans' lives better in any way? Of course not. They are making it harder for women to vote, doing favors for their billionaire donors, and trying to undermine the Constitution by eroding the independence of an independent judiciary. The SAVE Act is a voter suppression bill. That's all it is. 69 million women who have married and taken their spouse's name do not have a birth certificate. Do not have a birth certificate they could easily use to register to vote if this bill were to become law. Nothing in this bill guarantees they could use marriage licenses and name change documents to prove their identity. Nothing in this bill says that. It's about taking away the right of women to vote, plain and simple. We have two other measures here designed to make big banks even richer at the expense of working people. Again, you can't make this stuff up. With all the problems of the world, Republicans want to make it easier for your bank to charge you unfair fees. And then there's the so-called No Rogue Rulings Act. It's a blatant power grab to gut the courts. If a judge doesn't bow down to Trump or Republicans' extremist agenda, Republicans want to strip that judge's authority. That's nuts. If this were happening in another country, our State Department would condemn it. This regime is marching toward authoritarianism, trying to trample over the courts and undermine the rule of law. And we are absolutely not going to let that happen without a fight. Democrats want to lower costs, protect workers, expand health care, and invest in a future where everyone, not just rich Republican megadonors, can thrive. And we will not stand by while extremists try to dismantle our democracy and sell out working Americans. The American people deserve better, and we will keep fighting to make sure they get it. I yield back.
Thank you, Mr. McGovern. Without objection, any prepared statements that our witnesses may have will be included in the record. I now welcome our first panel, Representative Issa and Ranking Member Raskin from the Committee on the Judiciary. Your full statement will be submitted for the record, and we ask you summarize your statement in 5 minutes. Representative Issa, I welcome your testimony.
Thank you, Madam Chair. And for the ranking member, I'll summarize. Not only is this not a nuts bill, but I will include the following. The Biden administration sought in October of last year, asked the Supreme Court to invalidate lower court universal injunctions against the Department of Education, quoting an opinion by Justice Thomas and citing one by Justice Gorsuch. The Solicitor General argued that universal remedies are inconsistent with longstanding limits on equitable relief and the power of Article III courts to impose a severe toll on the federal court system. October wasn't a year ago. The fact is, the last administration, rightfully so, saw an expansion of these national injunctions in which plaintiffs not there, not represented, are being included in the decision. NORA, the No Rogue Rules Act, intends to rein in the most egregious of these activities. And we do so in a measured way. We're not saying that a judge does not rule a national role on behalf of any plaintiff before them. What we're saying is that when you don't have a class action suit, you don't have multiple circuits being represented before one judge, what you have is one judge representing one plaintiff, being represented with one plaintiff or one group of plaintiffs. You rule on behalf of that. Now, for nearly 200 years, until 1963, there had never been a ruling like that. And even after 1963, it still remained extremely rare. And yet, this administration has seen 67% of all the national injunctions ever granted against them. It is clear that it has gotten out of control. The fact is that with 38 TROs and preliminary injunctions enforced today, the High Court finds itself essentially forced to see case after case after case. It is not appropriate to do that, and certainly because in many cases these are extremely time sensitive. Will $2 billion be sent or not sent? The fact is, these decisions have to be made, and ultimately at the High Court. I would also note for the record that in a previous Congress, H.R. 9660 by Congressman Mondaire Jones substantially did the same thing. It didn't have some of the safeguards we had. It was actually broader. But when the shoe was on the other foot, my colleagues on the other side of the aisle recognized that this was getting out of hand. I would only ask the Rules Committee and the Congress as a whole to weigh fairly the question of the court and the question of this body. And I'll close with this. Madam Chair, the Supreme Court, those 9 men and women, were created by the Constitution. All other judges were created by acts of Congress, and their authority was determined by this body. Our fairly carefully crafted bill is intended to reiterate what I think was taken for granted for almost 200 years after the creation of the First District Court. And I would only ask that we pass this bill as a form of enforcement, but also as a form of reminder that district courts were created and called district for a reason. And I yield back.
Thank you, Mr. Issa. Mr. Raskin.
Chair
you're
Fox.
Recognized for 5 minutes.
Thank you kindly. And Mr. McGovern, Mr. Issa, look, we get it. Federal judges in 46 cases have blocked Donald Trump's executive orders and policies as unconstitutional. or illegal. The judges ruling in these cases were appointed by 5 different presidents, Republican and Democrat alike, in 11 different district courts across 7 federal circuits. The courts have explained in painstaking detail what is unlawful about these orders and policies, and Trump has offered no substantive critique of their legal reasoning. He just says the jurists deciding are, quote, radical left judges, including Chief Judge Boasberg, the Chief Judge of the D.C. District Court, who was nominated to the bench first by President George W. Bush and was Justice Kavanaugh's roommate at Yale. Some fanatics are now attacking and threatening the judges and even their family members, like Judge Boasberg's daughter, or Justice Amy Coney Barrett's sister, who got a bomb threat a few weeks ago. Some Republicans are calling the jurisprudence of these courts judicial warfare and are trying to impeach these so-called rogue judges. And some Republicans, like my friend Mr. Issa, are now trying to change the ability of courts to issue nationwide injunctions, something that Republicans took generous advantage of themselves in the last administration. The No Rogue Rulings Act would effectively ban district courts from providing nationwide relief against unlawful executive actions because litigants could request injunctive relief only with respect to themselves. For every American citizen to get protection against a president's illegal actions, each citizen would have to go to court and bring his or her own case. If this had been the law when Trump tried to revoke the 14th Amendment right to birthright citizenship by executive order in January, the judge would not have been able to stay implementation of the order nationally while the case worked its way to the court. Even though the executive order was, quote, blatantly unconstitutional and struck down by 4 separate judges, one nominated by President Reagan, one by Donald Trump, one by Joe Biden, and one by Obama, every affected person or family would have had to bring their own separate personal lawsuit because the district court injunction could only apply to the actual parties in the case. This bill is totally unworkable. Our judicial system of 94 different federal judicial districts could not handle the tidal wave of litigation that would necessarily follow. If you do the math, and you just had one person for every federal district in the country, it would take 12,220 attorneys to replicate the work of the original case, and then 12,220 defending prosecutors for the Department of Justice. Do the math. This is wholly unworkable. And of course, many people wouldn't have the resources to bring their own case and thus would be deprived of their rights and freedoms under federal law and the Constitution until the Supreme Court could rule. The whole idea of suddenly blocking nationwide injunctions because Donald Trump is losing every single day in court defeats the whole concept of the rule of law. Just as justice delayed is justice denied, justice circumscribed is justice circumvented. This is a principle Republicans not only endorsed, but took liberal advantage of in the last administration. Remember Judge Matt Kaczmarek of the Northern District of Texas? Republicans were lining up around the block to get cases against the Biden administration before him and praised the nationwide injunctions that he issued. They've even inserted a carve-out provision in this bill to ensure that he can still issue nationwide injunctions in a case currently before him. So don't tell me that this is a principle about nationwide injunctions. Even though Judge Kaczmarek was several times reversed, we never tried to ban the power of judges to issue nationwide injunctions, or at least I did not. These are essential judicial tools. We did try to stop the outrageous practice of judicial forum shopping, and Madam Chair, I would submit to you that's a real problem we could work on together. But our colleagues humiliated by this unprecedented losing streak in federal courts across the land should not try to convince themselves that there's something wrong with the courts. Read the opinions and you'll see that there is something wrong with the utterly lawless executive orders and policies lifted out of the Project 2025 playbook. Of the over 150 cases filed against the administration, some form of injunctive relief has been ordered in only 46 cases, and of those, only 17 were nationwide, or 1/3 of them, which shows that the courts are appropriately balancing all of the factors in the different cases. I call on my colleagues to take down the wanted posters with judges' faces on them outside of offices and House office buildings, temper their discourse when it comes to judges who are just doing their job, stop the calls for impeachment, and oppose this very unfit bill. Thank you, and I yield back.
Thank you very much, Mr. Raskin. Representative Issa, despite the accusations we're sure to hear from the other side, This legislation is even-handed, is it not? It would apply evenly to Republican and Democrat administrations in the future. Is that correct?
That's absolutely correct, Madam Chair, that we balanced them, including the recognition that if multiple multiple attorneys general in different circuits or multiple plaintiffs from different circuits, they would still be able to ask for a broader injunction, but they'd have to be plaintiffs represented and present.
So just to put a fine point on this, Congress's ability to establish the scope of jurisdiction of certain courts, as you said, is derived by the Constitution. You said that in your opening statements, correct?
Correct, that we have the right and we have defined district courts as more limited, and until for almost 200 years, they respected that.
Great. Thank you very much. Mr. McGovern, you're recognized.
Yeah, no, I agree with Mr. Raskin's assessment of this legislation. I don't know if you want to respond to anything that, or add anything before I yield back.
The committee is presented with a very interesting problem because Donald Trump has indeed suffered an unprecedented string of judicial defeats, like with the birthright citizenship case or attempts to usurp Congress's spending power, or the illegal sacking of federal workers who are on probationary status because they've been recently promoted to a higher job. He's been losing all these cases. So our friends say, well, that's because suddenly all of these, Bush and Reagan and Biden and Obama appointees have become radical left rogue judges. And we say it's because these orders and these policies are outrageous and unlawful and clearly unconstitutional. I mean, one Reagan judge said of the birthright citizenship executive order, this was the easiest case he had ever decided. And you don't need to be a lawyer to understand what's wrong with denying people birthright citizenship. You just have to know how to read. So I would prefer if we were discussing the substance of the opinions rather than blaming the judges, because again, it's getting very dangerous and risky out there for judges. And if you read what Chief Justice Roberts wrote in his annual report, he said that this has now become a pattern where people are targeting judges when they disagree with the opinion, just like the people who are now saying, impeach the judges. We've impeached 15 judges in all of American history, and it's always for bribery, corruption, habitual drunkenness on the bench, professional misconduct. And they're talking about impeaching judges because they disagree with the substance of their ruling, and the rulings are right. So Chief Justice Roberts said last week, when it was really getting out of hand, the proper response to a judicial opinion you disagree with is to appeal it, not to impeach the judge.
No, and I think that if the rulings were going the other way and everybody was agreeing with Donald Trump, we wouldn't be here with this bill today.
Well, and he's won some of these cases. He hasn't lost all of them. I mean, he's lost an extraordinary number for any president in American history, but they're not calling for the impeachment of the judges who sided with him.
And I've seen some of these signs in front of congressional offices with judges' faces on them, that unwanted posters, and I think that's inappropriate, and I would like to think that the leadership of this House would demand that those be taken down. Especially given the political climate that has been made even more coarse by the current occupant of the White House. But I yield back.
Thank you, Mr. Governor. Ms. Fishbach, you're recognized.
Thank you, Madam Chair. Mr. Raskin and Mr. McGovern have both talked about stopping the threats, take down the wanted posters. I would ask you to publicly then ask your side to stop threatening members of Congress. If you're concerned about threats, there are threats to Republican members of Congress from your side. Yes, there's wanted posters. I will get you copies of them because there's wanted posters of Republicans in their districts. And if you are concerned about threats, maybe we should talk about all the threats. There's one of our Republican members there's a guillotine set up in front of his office. You don't think that's a threat?
I haven't seen a guillotine since January 6, 2021.
It's my time, and there is one, and I am asking you both right now to publicly renounce, say, stop the threats against Republican members of Congress.
Then, to the extent that's happening, I'm not aware of it. I would absolutely denounce and renounce any threats against any member of Congress.
Thank you. And I would hope that you would talk to your folks about stopping those threats because they
you
are
give me a
real.
specific
We
example.
have members who have to wear. Yes, it is about, they brought up the threats, ma'am.
Yeah.
This is, and.
Madam Chair, I'd like to say.
It is my time.
Will you please
my
denounce
time.
Trump for sending a mob here on January 6th?
January 6th is not happening right
well,
now. The threats
you
are
didn't-
happening right now.
nobody denounced that on your side.
And it's my time, ma'am, sir. But I would suggest that when you start talking about these threats,
Yes.
that you talk about both sides. And I suggest that you talk to your side because you have been talking about January 6th for a very
Will you
long
denounce the
time.
threats against the judges?
I don't think anyone should be threatened. I don't think there should be wanted posters out there. But these are serious. I mean,
I'm glad for that.
we have members who have to wear bulletproof vests because of the Democrats coming after them.
Well, but I've had,
So I would
have several
suggest-
judicial restraining orders against people who have threatened me. So I can relate to what you're talking about.
Then you need
That-
to talk
that-
about all of them instead of sitting here in front of us saying that this is threats. And so I appreciate that you are going to denounce them
I'm
and you're going to
quoting the
work
Chief
with your
Justice of the
side.
United States of America who wrote about it in his annual report.
You talked about the threats. You brought it up. And they are serious against members of this body, Republican members of this body. And so I would appreciate it when you start talking about those things, that you talk about both sides.
You're aware that Democrats have received those threats too, so
I recognize that all of us have.
then we should all denounce it, we should all work against it, not just in the legislative branch, but the judicial branch as well.
I think the threats and what has been going on to our Republican members of Congress in the last month or so is inexcusable. I mean, when they have like the guillotine out in front, they're having to wear bulletproof vests because of the threats against them. And I recognize there's other threats, but this is right now, this is coming from an organized group of Democrats who are doing this. Yes, it is. Okay.
Well,
it absolutely is. You can go on and look online because it's right there.
That could lead to
That is
something like
right there.
January 6th, where 140 of our officers were wounded and injured, and so
I'm
we should
reclaiming
stop
my
it
time.
if that
I'm
exists.
reclaiming my time
Yes.
because I am talking about things that are happening right now that can be stopped. And with that, I yield my time.
Thank you, Ms. Fishbach. Ms. Scanlon, you're recognized.
Yes, I'd yield to Mr. McGovern.
And for the life of me, I don't understand why it is impossible for Republicans to denounce the mob that attacked this Capitol on January 6th and wounded 140 police officers. They can't bring them. Yeah, I know, and it continues, and so anyway, I yield back.
Thank you. And of course, we would denounce political violence. I'm unaware of any wanted posters. I have seen a lot of missing posters, like on the side of a milk carton, referring to Republican members of Congress who are refusing to meet their constituents. But turning back to the issue at hand here, I think we're all concerned about the fact that we have this authoritarian playbook occurring where in order to undermine civil society and undermine the rule of law, the accepted way to go about that is you attack the media, you attack the universities, and you attack the courts. And this proposed bill seems to be another way to attack the courts. I mean, if the president, as you rightly pointed out, if the president doesn't want to lose in court, he should follow the Constitution. I was really struck by the fact that forcing, everybody impacted by the birthright citizenship overreach order would just cause mass chaos in the courts. I mean, you want to talk about fraud, waste, and inefficiency. Right. I mean, forcing hundreds and hundreds of cases every time there's one of these issues seems to be a prime example of it. Did you want to say anything else on that?
Judges shrewdly and sparingly use the nationwide injunction, and they use it in cases where it would be an absolute burden on judicial economy to have hundreds of thousands or millions of people going to court. For example, a lot of people are upset about the potential conversion of their private data, like it's Social Security. And then there was a federal court which said that DOJ could not take people's Social Security data and needed to destroy the data that DOJ had taken. Why should that have to be litigated by, 200 million Americans who don't want their data corrupted or prostituted in that way? So, look, the Chairman Issa is a very smart man. I've gotten to know him pretty well in my few months in the Judicial Committee. I think he understands that you don't impeach judges because you disagree with their opinion. You appeal, right? And and so I think that this is analogous to that. We don't need to change the rules of civil procedure, to amend the rules of civil procedure to block out this tool that judges have at their disposal. It has not been misused.
I would agree with you on that, and it's just kind of making me blanch as a former attorney, thinking about every single American having to go up against Elon Musk and the U.S. government in order to kick Elon Musk and his buddies out of your own private data. I mean, that's just a total recipe for disaster. I believe there are other proposals on how one could address some of these nationwide suits. I mean, this is a pretty broad one that would basically eliminate, with the exception of the one very conservative judge who is already doing this kind of a case. So can you just comment on the selective nature of this bill with respect to what nationwide injunctions it's going to allow and those that it would not?
That's why I would love to hear from our friends a specific case or a group of cases that they think really should not have the benefit of a nationwide injunction. I mean, like on the Social Security data case, that's something that clearly has national implications, and it would be a ridiculous waste of judicial resources to be hearing that hundreds or thousands or tens of thousands of times, just like birthright citizenship. That's a very clean constitutional issue. The first sentence of the 14th Amendment says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. So how many times do you need to litigate that basic legal question? And of course, it's for a temporary period anyway. It's going up to the Supreme Court, but it says we're going to have a stay in deference to the rights of the people before the Supreme Court can get a hold of it. I don't think a single one, and again, I'll stand corrected by my friend Mr. Issa, I don't think a single one of these nationwide injunctions, which again is just 1/3 of the injunctions that have been issued, has been reversed by an appeals court. And so I go back to what Chief Justice Roberts said. The proper way to deal with this, if you think somebody's got it wrong, is you appeal the decision. You don't try to impeach the judge or change all the rules all of a sudden.
Ms. Scanlon, I could answer your question if you'd like.
Sure.
There were 17 of the cases that have been brought so far that for one or two reasons would not have been covered by this bill.
And are those mostly involving the use of mifepristone and medical abortion?
No. In most cases, these were brought and the judge did a national injunction, but only as to the parties before him. But in another case, the judge did in TGG versus Trump, he certified a class action. And that wasn't something that we did because of a previous administration. It's because class action lawsuits have historically included a class that went beyond one circuit, one district, and as a result, they did have national repercussions. So out of the first 38, 17 would in fact not be covered by this bill. We did limit multi-circuit and class action because historically those are viewed differently. And because a judge, we want the efficiency, and I think Mr. Raskin said it fairly well. We wouldn't want to have them have to go to 100 different districts. There are two ways that you can get a nationwide injunction historically. One is multiple different circuits applying before one judge, or quite frankly, to paraphrase the Supreme Court Chief Justice, if in fact you go to just two judges and you get two outcomes, you then have a case for the U.S. Supreme Court. And that, by the way, is historically how it's done.
I need to reclaim my time because I see the chairwoman checking the clock, and I know she's trying to rein all of us in.
Can I ask a consent request before you do?
Just in conclusion, I'm very aware of the strain that this kind of thing would put on our courts, but I'm more concerned about the strain that it puts on the people whose civil rights are being violated by these orders and the burden it puts on them to each one get representation?
No, I think, we had this exchange before Ms. Fishbach left, but I do want to ask unanimous consent to insert in the record. This is one floor below my office, in front of Representative Ogle's office, wanted posters of judges. It says, "No Get Trump Judicial Activists Wanted." And this is the kind of stuff that some of us are asking there to be universal condemnation about. I mean, this is threatening to these judges. It has no place in the halls of Congress. I ask unanimous consent to insert.
Not only would we want that, but
Without objection.
this committee has had a
And I
long
would yield
history of
back.
providing security. We are currently redacting the addresses and other information. So the one place that you'll find we won't be in front of you except united is on the security of the judges.
Can we get some agreement that members who put these posters up in front of their offices will take them down?
I don't believe we should be putting up pictures of judges.
And I thank Mr. Issa for saying that. I would hope also that all of the calls to impeach judges because members disagree with their opinions should be retracted, or at least that should cease immediately, because that is creating the climate in
We
which
should all be able to condemn this.
I think everybody should condemn that. I'm glad to hear Mr. Issa agrees that that should not be going up. But I think the whole thing about talking about impeaching judges who ruled in the birthright citizenship case or impeaching judges who are protecting our Social Security data is very dangerous. And look, Judge Boasberg's daughter has been the subject of an online campaign of vilification and intimidation, and Justice Barrett's sister got a
Thank
death
you,
threat.
Mr. Raskin. Thank you very much. I want to say, I believe for all Republicans, we do not condone any calls for violence against anyone. Anyone. We do not condone any calls for violence against anyone. Period. Mr. Langworthy, you're recognized.
Thank you very much, Madam Chair. And Mr. Issa, I thank you for bringing this legislation forward. I'm proud to co-sponsor it with you. I join the chorus here condemning violence against any elected official. We are all popularly elected in our districts. I mean, there should be no violence geared towards anyone. There should not be any violence geared towards anyone in the judiciary in this country. I think that should really go without saying and be universal. But I think as many as my colleagues do, there's a growing trend on these nationwide injunctions that is shaking the confidence of the American people in the judiciary to fairly and effectively do its job. And I think that this legislation is a step in the right direction there. Is there anything, with all the conversation that's happened here so far that you would like to add, Mr. Issa?
Thank you, sir. I would just try to reiterate that in the last administration, the Solicitor General, on behalf of the administration, it may not be on behalf of the Judiciary Committee's minority, but they called for an end to these excesses, and Congressman Jones offered a bill that would be substantially the same as this one, except, quite frankly, bringing even more of an end. So I think we're really dealing in maybe people don't want it when it's not their president, and they do want it when it is their president. But like so many things, if you do the right thing, as we change back and forth between majorities and minority, between presidents, we'll have done the right thing. We protect all judges, both with the Marshal Service and now with additional judges, or additional protection after things like the home addresses of judges being put on the internet and so on. The same thing goes here. We're protecting every administration by not having this continued growth. I will note, somebody said all of a sudden, but I held the first hearing on this subject in 2017. The fact is, this is not a new issue. This is an issue who simply we're seeing it get worse. And just as the Judiciary Committee had to deal with venue shopping in East Texas at one time, where about half of all patent cases ended up in one judge's hands, things can get out of hand. We're trying to rein them in. And again, I went out of my way to make sure that we did allow a path for appropriate nationwide injunctions. And then lastly, just as a point of personal privilege, this is not based on whether the president or any president wins or loses their cases. Presidents test the executive powers. The last one did it. He lost to a tune of $188 billion on forgiving student loans. But that was a decision that was made by the court over time, as it should be. And, I don't always agree with the outcome of court cases, but I always agree that that's the process. And all we really want to do with this piece of legislation is maintain the historic process. Two different plaintiffs show up in one courtroom. They get represented beyond any one of them. Two plaintiffs show up, even if it's the ACLU in two different locations. They go in two different locations. They get an outcome. They get to appeal it, and it gets to the Supreme Court. We want to preserve that. Again, if this had been something that went on for the first almost 200 years, we could say it was part of the original intent of district courts. It didn't. It didn't go on for about 190 years of our great nation, but it has grown now to where it is basically one case, one action by a judge every 2 days since this president came to office. And I thank you for your question.
Well, thank you very much, Mr. Issa. I'm very much looking forward to supporting this legislation on the floor. And then, back to just the discussion of violence against people in public service. I mean, we've had just a lot of instances. I mean, it was Senator Schumer that went and stood on the steps of the Supreme Court and told Supreme Court justices that they all have hell to pay. I mean, we have to set the tone. We have to turn the volume down. Over the weekend, the Buffalo News in my hometown decided to cover a protest of the Tesla factory in Buffalo. And God bless those people. They have their First Amendment right to do that. But the paper decided to glorify the image of one particular sign that showed a guillotine, and it said checks and balances. And that, to have a major newspaper in this country, glorify the image of people basically calling for the execution of elected officials is unacceptable by any metric. And I think everyone's got to take this moment and acknowledge the fact that we do have people that suffer from mental illness in this country and are more than willing to take drastic measures if they feel called to do so by what they read on social media or in the media. And all of us in public life have the same responsibility as well. So with that, I yield back, Madam Chair.
Thank you, Mr. Langworthy. Mr. Neguse, you're recognized.
Thank you. Thank you, Madam Chair. Good evening or good afternoon, Representative Issa and Ranking Member Raskin. Thank you both for being here. Thank you for your testimony. I'll preface my remarks, or my questioning rather, with the simple statement that I very much appreciate our partnership, Mr. Issa, and our friendship, and have great respect for you. But I do have some pointed questions about this bill, because I think this is a dangerous proposal that House Republicans have conjured that, in my view, ultimately is consistent with the broader attacks that Ranking Member Raskin has described about the judiciary. So let's start here. Have you introduced this bill before?
No, I held hearings on it in 2017, but there hadn't been. It was previously put in by Representative Jones on the Democrat side.
Sure, but I say, because I heard your colloquy there with Mr. Langworthy, and I just want to make sure we're clarifying for the record. This bill you had not introduced in the prior Congresses. No, I think, right.
But there is a justification for why the bill has come to us now.
Sure, please proceed.
You had one case in 1963. You went on for additional presidents without it, and then it began to grow. It grew to where the all-time record was George W. Bush. Then it went down a little bit, but not a lot during Obama. It went back up during Trump 1. It went down, but not to zero during Biden. What we've seen is a growth like this. Republicans get a little more of this than Democrats, but the fact is it's a growing trend. Each Democrat president gets more than the Democrat president before them.
Sure.
That's the reason that Congressman Jones introduced substantially the same bill in 2022, is that the problem is not that it's happened once. The problem is it's becoming the go-to solution.
Were you in Congress when President Obama was president?
Yes, I was.
And you were in Congress when George W. Bush was president?
Yes.
And you were in Congress.
I was here with Calvin Coolidge, if you're going back that far.
I don't want to age you here, but you were in Congress when Joe Biden was president.
I was.
You didn't introduce this bill during any of those time periods in question, right? Notwithstanding, as you said, there were many nationwide injunctions being issued by federal judges at that time. But lo and behold, it's only in the last 60 days that you decided to introduce this bill, right?
In fairness, there was a period of time when I was chairing a different committee.
I understand.
But also, former Congressman Mark Meadows introduced the bill previously. So it wasn't originally my bill, and it wasn't originally Mr. Jones's bill. This bill has come up a couple of times under both Republicans and Democrats.
I'll ask you a different way. You
don't like that way? That's a good way.
You seem very passionate about ending nationwide injunctions.
Not ending, reining in.
Fine. We'll use your word. You feel very passionate about reining in nationwide injunctions, right?
Unless they pertain to the plaintiffs before the judge.
Putting a lot of disclaimers on it. I mean, you call this bill the No Rogue Rulings Act of 2025. I don't think I'm misstating your position that, subject to the disclaimers that you've provided, you believe that there should be reining in of nationwide injunctions, right? That's why you're here. That's why you're submitting this bill, right?
That's correct.
Okay. During President Biden's tenure, there were 14 nationwide injunctions. Did you denounce any of them?
I'm not denouncing any of these.
Did you believe any of them should be reined in?
I haven't looked at the details of each one of the cases, but to the
Was there any that you made a public statement about?
Wait a second.
There were 14 of them.
To the extent that judges were ruling beyond the plaintiffs before them,
Sure.
I hereby would say that they were wrong to do.
Okay.
The fact is, judges should represent a decision for the plaintiffs before them.
Your team may need to go online and delete some of the social media posts that you've previously posted, right? Are you familiar with a case called Missouri versus Biden?
I don't recall that.
This was a case regarding social media moderation by the administration.
Oh, sure.
Sure. And on July 5th of 2023, this is on Twitter or X, what it was called back then, you said here on your social media, quote, "A federal judge is stopping the White House from colluding with big tech to censor your free speech on social media. Releasing this decision on Independence Day was right on target." Okay, this is your tweet, July 5th of 2023, celebrating a district court nationwide injunction against the Biden administration made by a district court judge in the Monroe Division of the Western District of Louisiana. You can understand why we would be very skeptical about the motives of our colleagues bringing this bill today, because they are disappointed and frustrated with decisions that have not gone in President Trump's favor, when as recently as a year and a half ago, you and many other of our Republican colleagues were praising these nationwide injunctions, clamoring for more judges to issue nationwide injunctions. And now you've seen the light. Explain to me how that happens.
Since you've studied that one, did they rule beyond the plaintiff before them?
It was, I believe so. It was a nationwide injunction. We'll get you the decision. If you want to parcel through, we can go through each of the 14 injunctions, nationwide injunctions.
That's why I made the list so far of 17 of the decisions would have still stood under this bill.
Okay, we will go through. I can promise you, Mr. Issa, we've got a great team. They'll go through, they'll pull every nationwide injunction that was issued during the course of President Biden's time in the White House. I suspect we're not going to find any statements from you denouncing or disagreeing or believing that those nationwide injunctions, provided they meet the disclaimers you've stipulated to. I don't know. I mean, are you contending that was the case?
I think you'll find that some of those 14 would survive, a significant portion of them would survive under this legislation.
Sure, but the ones that wouldn't survive, you weren't taking issue with them in the past.
In fairness, every single one of them would still survive. They would simply be limited to the plaintiffs before the judge.
Mr. Issa, I would simply suggest, I know that, because I know Ranking Member Raskin real well, I know that he was disappointed when there were decisions made by federal judges issuing nationwide injunctions by virtue of the forum shopping that Republican attorneys generals had done during the course of the Biden administration. I suspect he was disappointed. What he didn't do was come before the Rules Committee and ask our committee to end nationwide injunctions as a matter of course in federal law. He didn't do that. How do I know that? Because I'm on the Rules Committee. I was here during the course of the Biden administration. He wasn't here asking us to do that. So I would just implore you, and I know this is your legislation, so I suspect that perhaps this is a tougher request for me to make, but I would certainly implore my colleagues on this committee to reconsider their support for this legislation. I don't think that it's in the best interests of judicial economy or adherence to the rule of law. I get it. You're frustrated. I understand that temptation, but we don't respond by changing federal law so that judges can no longer provide the kind of equitable, inherent, and injunctive relief that they have provided since the inception of our republic. Ranking Member Raskin, do you care to expound on this?
Yeah, Mr. Negos, thank you so much for your thoughtful comments. It brings to mind actually the conversation I had with Mondaire Jones about this, because he came and asked me to join the legislation, and he was invoking what was happening with Judge Kaczmarek and a few other rogue, right-wing judges who were imposing nationwide injunctions on stuff. And I said, I couldn't sign on to it because I believe that courts should have that authority. That doesn't mean I agree with what he did in that particular case. And I am definitely against the forum shopping, which I think is the real problem we should be talking about. But the fact is, just because somebody misuses a rule doesn't mean that the rule itself is wrong. And the rule is capacious enough so that if there are nationwide implications of a particular unconstitutional act or order, and we might disagree about what they are, then the court can act in that way. And I think that happened in the Biden, forgiveness of the student loans and so on. But I said I couldn't do it for that reason. Now, in defense of Mr. Issa, I'm not sure he wants me defending him, but I would say that I've been very concerned about what's taking place with the judges. I went over to the Judicial Conference at the Supreme Court. I think Mr. Issa was there that day too. We spoke to a bunch of federal district judges, appeals court judges. Chief Justice Roberts was there. These people are very upset and anxious about, one, and I'd say above all, the physical threats, the violent intimidation, the attacks by the President of the United States, yes, Elon Musk, on judges online, because they understand millions of people read those. And they're also very upset about converting a substantive doctrinal difference into cause for impeachment. So I would say, and I'm not speaking at all to Mr. Issa's motives, because I know he really believes in this, but I would say this is a much safer way for people to have an outlet for their frustration to talk about this rule than what is going on in the halls of Congress and in the streets.
Madam Chair, I'm concluded, but I do want to give Mr. Issa a chance to respond if he'd like.
Well, I'd only say that I'm sorry you didn't sign on to his bill. It was actually pretty good. But I will say one more thing, maybe for everyone. The Biden administration Solicitor General said, and I quote, that these national injunctions, they operate with asymmetry. One of those words I can't do. The government must prevail in every suit to keep its policy in force, but plaintiffs can derail a federal program nationwide with what but a single lower court victory. And that is really the crux of why we wanted to be limited to the plaintiffs before a judge, so that his or her ruling applies to those plaintiffs, but it doesn't create a situation in which literally you can lose. The plaintiffs can lose 5 times. You just have to find one judge where they win, puts a nationwide injunction, and then for a significant period of time, that becomes the law of the land.
When did he issue that statement?
This was she. It was in October of as she was just before the election.
With her departure. So again, we've belabored the point.
Well, they thought they had another term.
I hear you. I appreciate the chairwoman's indulgence. I would just simply say, Mr. Issa, again, you can understand our skepticism, given that you did not introduce this bill. When the Solicitor General made her remarks, you didn't announce publicly your support for her position on nationwide injunctions, nor did any of your colleagues. You waited until Donald Trump had been elected president, and of course, here we are. So with that, I yield back.
Thank you, Mr. Neguse. Mr. Griffith, you're recognized.
So, Subcommittee Chairman Issa, am I interpreting that one of the reasons you might have waited is that the bill would not have stood a chance in the Senate, since the Senate was not controlled by people who might be friendly to this bill?
That is absolutely correct. And Senator Grassley, of course, has a companion bill he's working on.
And I just have to say, and I think you touched on it a second ago, it is hypothetical at this point, but in theory, without your bill, and assuming that the principles of res judicata and collateral estoppel would not apply, you could have 5 judges, district court judges of the 94 different districts, turn down a national injunction and then have one implemented. Is that what I heard you say?
That's absolutely correct, that you could lose time and time again until you got one win, and then you'd have a national injunction.
So in reality, if the issue's raised in two different circuits, in two different states, this actually does create judicial economy, does it not?
It absolutely does, because that's historically where the high court looks for those two different differences and takes a case. But generally, the entire nation and the administration isn't held to a standstill waiting for the time it takes to get to the Supreme Court. And it's that time that causes a ticking of an administration's legitimate right and obligation to administer.
All right, I appreciate that. Now I'm going to put you in a little bit of an awkward situation, but it's what came to me. I'm going to put you into the role of Michael Phelps. As my colleague on the other side was saying.
You are talking about the Olympic swimmer, right?
I am talking about the Olympic swimmer.
Okay, Mexico, what was it, 8 of them?
He won a bunch.
Mexico City, he just kept winning.
So
if you're going to hold me to that size hand and swimmer, I'm proud to try do my best.
I appreciate that. And here's the issue that popped into my head. All swimmers were allowed for many years to wear a full body suit made out of high-tech fiber. Phelps competed wearing that suit. But after several competitions, he realized, and it was a number of years, I want to say it was 4 or 5 years, he realized, looking at things in hindsight, that records were falling at a faster rate than historically had fallen in swimming. They're always falling, but he recognized that they had fallen at a faster rate, and he recognized that it might be the full body suit, and he championed to the International Olympic Committee that those suits, not that the records be gotten rid of, but that the Olympic suit be changed so that it's just a jammer that is basically waist to above the knee, as opposed to a full body suit. I sense that's what you're doing here, that looking at the history, you recognize that things are trending in a way that is not good for the American judicial system. And even though you may have made comments on some national injunctions previously issued by a district court, even though you may not have thought deeply about it until 17 or until the comments by the Democrat Solicitor General in October, looking like Michael Phelps did, looking back on the record, you recognize that this is not good for the judiciary, just as he recognized it was not good for the sport of swimming, and championed the cause. And it's really the reason that they stopped allowing those high-tech suits to be any more than just waist to just above the knee. So do you see the analogy, and do you agree with it?
I couldn't agree more that I not only champion this now, but I would champion it in the future until it becomes law, because the good of the court is important. And I might note something else for the record here. There's a Rule 65 of the court that requires that you bond these decisions. And to my knowledge, none of these decisions are being bonded. And as we work, Mr. Raskin and I work with the Judicial Conference, we'd like them to live up to their rules. Those rules are there for a good reason. The fact is, when a judge orders that a plane turn around and come back, that's fine. But if that's overturned later, where do we go to get the administration back the adverse cost of that decision on which there was a plaintiff asking for that? So we have a number of things we want to do. Mr. Raskin and I are working, a number of members of the committee are even co-sponsoring it, to expand the size of the court. Now, I'll be honest, we've been trying to expand the size of the court since 2000. We haven't succeeded. You're exactly right. It comes a time when you realize something has to happen, and I would only be held that I not change until we accomplish it from the time I recognized it, and I will promise you that.
I appreciate that. One other thing I want to clear up, because I've been reading the bill and I can't find it. I'm sure it's in there somewhere. But early on, one of my colleagues on the other side of the aisle said that this bill particularly exempted, or at least they implied it exempted, an individual judge that Republicans had liked. And I don't see that in the bill itself. I'm guessing that what it is that you're not affecting any pending cases. Is that what I'm understanding?
In cases in which an injunction, this doesn't preempt existing injunctions that are going through the process. It does apply to all district judges equally. And it quite frankly, we're frustrated to find that it doesn't have more acceptance. The area that Mr. Ruscom was particularly concerned about, the idea that we would allow plaintiffs to come and they still would get a national injunction, was really put in out of fairness to the history of class action suits. And as a Republican, class action lawsuits are not necessarily what we're known for, but we do recognize that when a judge is faced with cases for efficiency that are coming from multiple circuits, that in fact they rule more broadly than their district. And we could end more injunctions if we did that. That's not what we're trying to do. We're simply trying to say, you're supposed to represent a decision of the plaintiffs before you and not plaintiffs that, again, are outside. There's a district court judge in another district in another circuit that might rule differently, and that's their right, is to rule differently, and then the U.S. Supreme Court to reconcile those differences.
All right, I appreciate that. I will tell you that that is of great concern to me. In a bill that we had in the last term, we changed the rules on pending litigation related to pipelines, which just struck me as unfair, and I did not care for that particular provision. So with that, Madam Chair, I yield back.
Very much, Mr. Griffith. Ms. Leisure-Fernandez, you're recognized.
Thank you so much, Madam Chair. Representative Issa, you've publicly stated your support for Trump and Musk and what they are doing. Democrats see it as that there's a lot of firings and chaos, and we're worried about what's going to happen to Social Security, what's going to happen to veterans, what about all the contracts that have been frozen. And that would happen in your district as well, right? You have a lot of veterans in your district. You have a lot of federal contractors, I suppose.
As someone who represented Camp Pendleton and the Brave Marines for 18 years, I not only have that, but I have a lot of active duty.
Exactly. And so, but you weren't supportive of what Trump and Musk are doing, correct?
I have served in this body, with the exception of the 2 years that I worked for Trump. I've served in this body for going on 25 years now, and I've watched us build up a deficit and a debt that I am extremely concerned that someone, in this case President Trump and Elon Musk, has to take on, because this body has been unwilling to deal with now a $2 trillion deficit. So I'm extremely concerned that we have to eliminate waste, fraud, and abuse, that we have to go after people over 115 years old who claim to still be on Social Security.
But in general, the point was you are very supportive of what Trump and Musk are doing. We are very concerned about what's happening in our district, so we are raising those concerns. It makes sense that you, as a Republican, elected with your positions, is supportive of what Trump and Musk are doing, despite what might be happening in your district. But
no, actually, I have 55 miles of the Mexican border.
So
I am interested in what he's doing because of my district.
Fine, because of your district. Fine, whatever it is that you are, right? But the reality is that when there is a president in power with a House and Senate, you are not going to get as much of the checks and balances that the Constitution anticipates. And that's when we turn to the courts.
You know, the Federalists did not anticipate quite as many checks and balances by party.
It's my time. And that's when we turn to the courts, right? And that's when we turn to the courts. And so our concern, when we look at a bill like that, when we look at the statements that come repeatedly from Trump and from members of this Congress that want to attack the courts, that do not want to honor court rulings, we become concerned. Because we need, and the framers considered, a checks and balances that said Congress can do oversight, but when the House is not willing to do any oversight of this administration, then the plaintiffs have the right to go to the courts. And some of the reason we are seeing the number of injunctions is because there have been a record number of executive orders. This is about 3 times the number of executive orders of any president in the first 100 days, right? Biden only had maybe 37. So the fact that you're having these many injunctions is probably coming from 2 places. One is that there are so many executive orders, and 2 They are simply being found unconstitutional, illegal, and triggering the injunction by judges that have been appointed by Republicans, that have been appointed by Democrats, that have been appointed by Trump. And so that's where we come to this. Now, Ranking Member Raskin, what do you think when you see these numbers of injunctions coming out because they are, as they put it, flooding the zone?
Well, thank you for the question. First of all, President Trump can issue as many executive orders as he wants. He could do 5,000, he could do 5 million. But if they're unconstitutional, they're going to be struck down by the courts. So there's no limit. And people should understand what an executive order is, because I think there's been a lot of confusion about this since the administration started. An executive order does not prevail over a federal law, over a federal statute, nor, of course, does it prevail over the United States Constitution. An executive order is an order from the president to the executive branch to interpret a law or a policy in a particular way. So he's got a right to do that. Of course, the citizens, as you say, also have a right to go to court if what he's doing is unlawful or unconstitutional, and that's all that's happening. And I wish my friend Mr. Issa, who again, I repeat, understands the law in a very deep way, would identify one case where he thinks the judge got it wrong, and we could actually talk about a matter of substance instead of saying, oh, there must be something wrong with the whole legal system as it's grown up over the centuries, right? That doesn't make sense to me. And, take the birthright citizenship case. We've got conservative Republican judges, we got liberal Democratic judges. They're all saying the same thing, which is it's in direct contradiction of the 14th Amendment.
Right, and that's in the Constitution. So if you're issuing executive orders that are in direct opposition to the Constitution, you can expect that you are going to lose in court.
He can be the all-time champion of executive orders if he wants. He can be the Olympic first place holder like Michael Phelps of Maryland, but not for swimming, for executive orders, and issue the most number of executive orders. But he also could be the #1 president in terms of having executive orders struck down. It doesn't mean there's something wrong with our system.
Right. And the fact that when you lose in court, talk about Michael Phelps and the sports, when you lose in court, when you lose in the field and track, you don't then go back and say, I want to change the judges, which is kind of what they're doing. Since we're on the sports metaphor, they're saying, no, let's change the rules, let's change the judges, and once we change the judges, or we say we won't have anybody judge us, so that way I can proclaim that I won. Right? That's sort of what this feels like, is they keep trying to change the rules, and this time it's going after the courts.
Well, Bonnie and Clyde should have just denounced judicial activism, right? Butch Cassidy and the Sundance Kid should have said, well, it's nothing that we did, it's these liberal rogue judges who are going after us. I mean, that's essentially what's happening right now. We're in the middle of a constitutional crime spree against due process, equal protection, the First Amendment, the separation of powers, the power of the purse. The judges are reacting appropriately, to my mind, and now the judges are being attacked and vilified.
Right. And I mean, and the issue is when the courts rule against you, and these will eventually make their way to the Supreme Court. I mean, it's not like there isn't already a system to resolve any contradictions among the district courts, and then when it goes up among the circuit courts, and then to the Supreme Court. So there's already a system in place. Nothing is broken right now with regards to this, other than that President Trump keeps losing. Is there anything else you'd like to add?
No, other than I think you're making the point that also Chief Justice Roberts made. He went to pains to say the proper response to disagreement with the judge is to appeal the case, not all of this other stuff that's going on.
And it is very rare to have a Supreme Court justice issue a statement the way Justice Roberts did, because it was so extreme, the attack on the courts and impeachment and on the judges.
And that's correct? A court that has ruled in Donald Trump's favor in some major cases, including Trump versus Anderson, including U.S. versus Trump about presidential immunity, creating a whole new doctrine. So it's not as if this court is somehow biased against him, but he seems to be very concerned about the direction in which things are going right now.
So if we don't have a court system that can adequately respond to a president, then do we have a democracy?
Well, the whole reason that we had a revolution in America was against a monarch, a king. And Madison defined tyranny as the collapse of all powers, legislative, executive, and judicial, into one. And so that cuts completely against the whole meaning of the American experiment.
Thank you very much. Madam Chair, I yield back.
Thank you, Ms. Leisure-Fernandez. Ms. Houchin, you're recognized.
Thank you, Madam Chair. Thank you to the witnesses. I've been taking some furious notes over here, Chairman Issa, on some of the comments that we've heard from the other side of the aisle. One of the comments that has been said is that this bill will end injunctive relief, but it doesn't end injunctive relief. In fact, it provides a mechanism to allow for it under certain circumstances. Is that correct?
It doesn't end injunctive relief at all as to the parties before the judge, but it does provide a process when if you will, there were multiple plaintiffs, but not all the plaintiffs were present.
And I might argue that this process that you have put in place is a mechanism by which it is a protection for some of the things that our friends on the other side of the aisle are concerned about. Permits a district court to issue a nationwide injunction where at least 2 states' attorneys general from different judicial districts are plaintiffs, and provides that such a case must be heard by a 3-judge panel. That seems to be a much better system than one unelected federal judge making a national injunction.
Absolutely, and then it also, in that situation, gives an expedited trip to the Supreme Court after that 3-judge panel is ruled.
That's terrific. So does this bill prevent the Supreme Court or any other court from issuing a ruling?
Not a bit.
Does this bill protect or prohibit any type of appeal from moving forward?
Not a bit.
Not a bit. Does it place the judicial branch in one, so does the current circumstance, does it not place the judicial branch and one unelected judge above the presidency?
You hit the nail right on the head. It defines that a federal judge is limited to the plaintiffs before them when they're a district judge, and does not give them powers not only superior to the president, but superior to 9 men and women of the high court.
So we're supposed to have co-equal branches of government, but it seems under the current circumstance, if a lower court judge who is unelected in one jurisdiction can issue a nationwide injunction enjoining the President of the United States, that seems to be placing one branch above another, and that's a huge concern.
It absolutely was intended to retain that balance, and if I could, there were a number of requests for examples, and I'll give you just a couple of them that we're seeing, and it doesn't matter which way the judge ruled, but for example, a judge ruled that the president should disperse $2 billion that he's holding against an investigation on fraud. That's fine. We'll leave that one alone, but it's a TRO. Here's one that you'll love. Men serving in women's prisons, in other words, men who identify as women being placed in women's prisons, even if they have a history of rape of women. That is a nationwide injunction. Under my bill, they might be able to order one prisoner who's a plaintiff who demands to be placed in there. They might be able to make that decision. They wouldn't be able to say to the entire federal system that overnight those prisons would be flooded with that. That would take the time, which means there'd be a chance for the high court to say, that's ridiculous and dangerous. The same thing goes with forced mutilation of children. There's the funds for it. There's a number of these cases that are simply policies of the previous administration being reversed by this administration, but the court is standing in there saying, yes, we understand that the first Trump administration was one position, Biden reversed it and got away with it. Now you want to reverse it back to where it was in your administration? No, you can't, and I'm going to ban you. We're trying to get down to plaintiffs and districts as it should be. And as I said earlier, I can go through 17 of the 38 cases that would still go forward because they limited themselves, most of them limited themselves to the plaintiffs before them. We're not trying to neutralize the importance of the court in the balance, but we're not trying to raise any one judge to be superior to 9 men and women of the Supreme Court.
And is the term national injunction, is that a legal term?
I don't believe that it is.
It is not. Is it defined in federal statute or in a majority court decision?
No, it is not.
It is not. So the term national injunction is something that is within the lower court. It's defined maybe in a lower court ruling, but it hasn't been around forever.
Nope.
And it's not something that's been legislated.
Not at all.
In federal statute.
Although from the beginning of time, a plaintiff and defendant, when they left that court, knew they were enjoined anywhere they went. But again, it was the plaintiff and defendant before them, not parties that were, quote, not present.
So let me ask you this question. Before nationwide injunctions, were judges powerless to protect people's rights in cases like Brown versus the Board of Education?
Not a bit. For 190 years, we did just fine without the so-called nationwide injunction.
And so we've heard a couple of things saying that this might be unconstitutional. Doesn't Congress have a role in determining the scope of federal jurisdiction?
Yes, it does.
Judges can't just issue injunctions without somebody petitioning for it in a lawsuit. Is that correct?
They are not allowed to operate de novo. There has to be someone who has nexus to them according to the statute.
So this may be the most extreme example of a concern that I have if we continue under the current pathway without passing your bill. If a judge is able to issue an injunction, for instance, to say that troops cannot deploy, that's one judge, unelected, taking authority over what should be the decision of the President of the United States. We had a similar circumstance, in my view, that the issue to return a deportation plane was made by a district court judge against the wishes of the President of the United States and his military authority to protect our national security in what he sees as commander-in-chief. So under those circumstances, it's very concerning to me. We know that the Congress does have the authority to legislate in this manner under Article 3. You are well within the bounds of that directive. We do have outstanding concerns. Maybe they were highlighted by this administration, but there have been other circumstances. And what you're doing is not saying that national injunctions can't take place. You're saying that these cases can move forward, they can be appealed, they can be taken all the way to the Supreme Court. It's just that the actions of the president would not be enjoined by one judge.
Exactly right. And in the case of that airplane, for example, had they come with a plaintiff, one of the people on the plane, asserting that that individual had been wrongfully identified as a member of a terrorist organization, wrongfully identified as undocumented and illegally in this country, then in fact, they could have petitioned for that individual to be left on the plane and brought back. That would have been appropriate, but that would have been a plaintiff with a case, not a party moving saying this is an injustice. Earlier I was asked about, am I happy with this administration as a Republican? Am I happy with President Trump? Well, I'll tell you, my district with 55 miles of the Mexican border, my district with fentanyl coming over the border by the tens of thousands of pounds every year, my district where we, in fact, had to take the burden of this massive importation, my district, which, by the way, has now been identified to have people in almost 1 out of every 5 people let over the border are on Medicaid, and many of them are registered voters and voted in the last election. My district is better off because of these actions, and anything that slows that down, that slows down President Trump asserting his legitimate obligation, is adverse to my district. So yes, I'd like to see the president able to do his job. I respect the court, but the court needs to have a plaintiff and represent what that plaintiff brings in the way of evidence, and not simply make decisions because they don't like this president.
Well, thank you. National security decisions are constitutionally delegated to the president. Federal district judges do not, in my view, have authority to supersede the president's decisions on matters of national security, like you mentioned. Interestingly, we know this, no one votes for federal judges. We do this so judges can act free of political influence. When judges do become political, however, and when judges encroach on the powers of the other branches, they erode the justification for their protection. This when this happens, they invite this kind of reforms that we see in this bill. I'm happy to support it, and I yield back.
Thank you.
Thank you, Ms. Houchin. Mr. Jack, you're recognized.
Thank you very much, Madam Chair, and I'll be brief. I'm just curious if I can start with Mr. Raskin. It's not the purpose of this hearing, but of the 17 nationwide injunctions, so to speak, that have been issued since President Trump was sworn in, are there any with which you disagree?
None are coming to mind. I've read pretty much all of them. I mean, the birthright citizenship cases, I assume you would agree with those, or perhaps not, and we have very conservative judges ruling the exact same way that Democratic appointed judges have ruled on that. And now, unlike Mr. Isa's district, my district has a lot of federal employees, so I've been very concerned about the mass firings of probationary employees. Probation sounds like they did something wrong. Actually, they've been promoted, or they just started off, but the courts have struck those down because they're saying that they have the civil service right to be treated as an individual. A lot of them have superior evaluations, and were nonetheless fired, and the court said that's really a RIF, it's a reduction in force, and you've got to use the specific rules on that, protecting veterans, for example, because 30% of federal workers are veterans, and so a lot of my constituents are veterans who got sacked illegally. So I would say I can't think of one.
Thank you.
Yeah.
Mr. Issa, if I could ask, we've talked a little bit about the history, 190 years, and I think, as I understand it, there have been 17 injunctions filed, nationwide injunctions, this presidential term of President Trump, the first term, 55, and I think in the 20th century, just about 20. If we were to rewind backwards, at what point did this, concept of nationwide injunction begin? Is there a specific case? And obviously, happy to defer to Mr. Raskin, too.
I know the professor would know it better, but there was a 1963 case that was sort of landmark, considered to be one of the first. But you're exactly right. It was so rare that people didn't see it as much of a problem, even if they disagreed with the case. And it is interesting that the ranking member couldn't give you one example of one that he disagrees with now that the shoe's on the other foot. This legislation, though, is not about whether you agree or disagree with the actual decisions. This is about having the judges rule as to the plaintiffs before them as a routine, rather than simply saying, well, I'm not worried about who the plaintiff is, I'm going to make it nationwide. The basic concept is that the arguments are between a plaintiff and a defendant. The cases can be different. And the example that I gave of there may have been one person on those airplanes that could have said, I'm not really a member of the group, I just got the tattoo because it looked cool. I don't know what their reason might be, but that wasn't what was before the judge. The judge simply said, I'm not going to let you take a law that has been on the books since our founding, virtually over 200 years, and execute on it because I disagree with the law. That we're going to say they have to have due process, even though the law for 200 years, 250 almost, didn't say that. So that would be my most egregious example. That turning around of the aircraft when in fact he wasn't speaking on behalf of a plaintiff, but was simply speaking that he didn't agree with a law that had been unchanged since the late 1700s.
Mr. Jack, thank you very kindly. I think that's a great example, Judge Boasberg's courtroom and the deportation case. So Mrs. Houchin, forgive me if I'm pronouncing your last name right. Is that right? Houchin, yeah. Mrs. Houchin said that the president exclusively has the national security power, and I beg to differ with that. If you look at the 1798 Alien Enemies Act, the Congress said that the president would have the authority to remove people from the country in two situations, okay? One is if we are at war with that country, if we've declared war against the country, or two, if we're incurring or suffering from a military invasion, right? And Judge Boasberg, again, a Bush appointee, when he first got onto the court, said, well, Congress has not declared war, we're not at war with Venezuela, and there's no military invasion. So for these people to be swept up and deported from the country, you've got to use the INA, the Immigration and Naturalization Act. But that requires a due process hearing, as everybody knows. But there was no hearing, And so this gets, to my mind, like the two most beautiful words in the English language, due process. You know, there was a guy who, according to his family, we don't know because it wasn't under oath, but a guy in Dallas who was picked up, and the basis for his being picked up, according to him, was a tattoo he has for Autism Speaks. His younger brother is autistic, and there's pictures of him together with the tattoo. And that was somehow seen as a pro-gang tattoo. He said he never met the gang, he had nothing to do with the gang, and he was deported, but nobody knows because there was no due process. So the reason why the due process hearing is necessary is because the original statute was improperly invoked, because we were not at war and there was no military invasion. So at the very least, that's a credible and plausible analysis of the legal situation, and Boasberg should neither be impeached nor vilified, and I don't think it's cause to completely change what is this fixture in our civil procedure system.
And I would only say that the professor took a little bit of liberty there. The word military is not in the statute. So he may be interpreting that it's about military, but we are under an invasion. We're under an invasion by organized crime. That organization has been deemed as a terrorist organization. The president was well within his jurisdiction to say that they came with weapons, they came equipped to conduct it, and that organization recruits and comes over here for that purpose. So did it meet all of the elements? Absolutely, and I believe when it eventually gets through the high court, it will. Again, I agree with my ranking member. There was a perfectly good reason to say person X may have had a tattoo. There may be a reason. But that would be a plaintiff saying that person asked to be turned around on an airplane. It doesn't change the fact that it was an airplane full of people that we had very good evidence were in fact members of this terrorist organization. They were active in their crimes and their beliefs, and the president was expeditiously removing them. And I would only say one other thing. The ranking member talks about immigration acts and so on. Under those acts, the right of due process is limited and administrative. It is not as broad as it is for American citizens. So even if one were to say, was there an administrative procedure, the president's entitled to have an administrative procedure that is quick and doesn't automatically go to a federal judge to make a blanket statement. So was Mr. Boasberg overly broad? Yes. Was he wrong? Yes. Am I going to vilify him? No. But I do disagree with his decision, as I disagree with the ranking member's interpretation of the 1798 law.
Thank you. And just one last question. Mr. Raskin, you're obviously a well-educated constitutional law professor. I'm curious, just to be clear, do you feel this law falls within the scope of the Constitution? Is it constitutional? Did the framers intend for us to be able to limit the scope of some of these courts and their nationwide impact?
Well, I'm sorry, which law are you referring to?
Sorry, the law that's being proposed, the bill upon which you're testifying.
Oh, well, that's a good question. You know, I don't know that the law the way it is today is constitutionally mandatory. So, I mean, I think this is a reasonable debate that we're having about it. But I will say the reason I turned it down strongly when Mr. Jones came to me was I immediately thought of Brown versus Board of Education, and I thought about Linda Brown. And I thought, well, when she finally summoned up the resources and the energy and the courage to bring her case to court, should the court in a case like that just rule desegregation is unconstitutional for you and your school district, and if there's anybody else in the country who's in the same situation, they can go to their federal district court. And that just doesn't make sense to me as a matter of judicial economy or fairness or constitutional rights.
Thank you. I yield back. Sorry, Mr. Issa.
I just want to share one thing. I happen to have a fairly unique district in that 70 miles into my district, you go through a Border Patrol check station. That doesn't occur in many places. But the High Court, the United States Supreme Court, back in the 30s, held that, in fact, secondary points in which Americans are the entire city of San Diego and many other suburbs are south of that border. And yet we drive through a Border Patrol station every time we head north. And we do so because of the nature of catching and apprehending people illegally in the country, people who may represent a threat. And we do so every day in my district. And I only say that because many people want to pretend that the war against this invasion, the war that the president is fighting today for all of us, they want to pretend that somehow that has to all fall under common due process. But the courts at the highest level have said illegal immigrants do not have the same rights as American citizens, and that is something that will be decided by the High Court during this administration, because this president is doing for us what the last one undid for the American people.
Thank you, Mr. Issa. Mr. Norman, you're recognized.
Thank both of you for coming in, appearing today. I think there is another side to it, too, Congressman Issa, is the fact that just the logic when Bozeman, I don't know if I'm pronouncing his name right, ordered the plane to come back and bring the basically gang members and murderers back. The American people just don't understand that, and that's why I think the president's approval ratings are so high. One of the things they didn't understand when the Biden administration wouldn't let Elon Musk rescue the astronauts who were there for months and should have been there 12 days. They don't understand that. But this is one of common sense, and you do think that, the Aliens Enemies Act does give him the authority.
I do. I not only believe it gives them the authority, but it gives them essentially a mandate to protect us from this invasion.
Right. Now, I guess the court the panel of three, to settle, if a federal district court issues a nationwide injunction, have a safety valve for a panel of three.
Absolutely.
And who walk me through who pays for that? Where is it? How is it chosen?
It's chosen at random
By
the circuit. They all have that basic assignment rotation. As a matter of fact, in some cases, they actually have a bag with all the names and they pull them out. And that is fairly well respected, the random nature of three-judge panels.
Okay, and you mentioned a bond.
Yeah, under Rule 65, every one of these cases brought and asking for these injunctions, that rule says that they cannot issue that injunction without the bond. And yet they're doing it again and again and again, as though it says may instead of shall, as though it doesn't say exactly what it says, which is in order to do it, they shall have a bond of sufficiency for the offset. And it just isn't happening. And this is an area where many of us on the Judiciary Committee, several of us, we go before the Judicial Conference. And it is an area that has been brought up before, and I will bring it up again the next time, that this is something that the Chief Justice and the Judicial Conference need to enforce. And if they don't, we might have to take Rule 65 and turn it into Law 65, because it's good for a reason. You get frivolous cases when it costs the plaintiff nothing. You get better cases when there's a risk if they're wrong and the damage they cause can be brought back.
It's called consequences, isn't it?
Consequences matter.
Well, the ranking member or I guess stated when it was his time to talk, that he really cares about the lives of our troops in danger. Where was he when he left the 13 Americans in Afghanistan? Where was he on the astronauts? How about those lives? I think it's to say anything otherwise, and it's kind of hypocritical for him to bring that up.
Hundreds, if not thousands, of Americans are alive today because tens of thousands of dangerous criminals who are unlawfully in this country have been arrested and deported.
Yeah. Well, thank you for the bill. Fully support it, and I yield back.
Thank you, Mr. Norman. Mr. Scott, you're recognized.
Thank you, Madam Chair. I apologize for being late, but the weather conflicted with Delta Airlines, and sometimes that happens.
Safety first.
What's that?
Safety first.
Yeah. I intend to support the bill. I don't have any questions. I would point out that Brown versus Board of Education was a Supreme Court ruling. We're talking about district courts here, if I'm not mistaken. Is that correct? And there's a big difference in a Supreme Court ruling and a district court ruling.
There was no nationwide injunction at the lower court in Brown v. Board of Education.
That's right. And I do believe that the president has done the right thing in taking some of the most violent people in the world and getting them out of our country. And so I commend him for being aggressive enough to do this. I think for the last several years, the cartels have controlled the border. I think it absolutely is an invasion. I think if you look at the number of people that have died from fentanyl, you know, that would lead you to believe that it was an invasion as well. And I would just ask, just this one question. I mean, the law is still on the books, right?
The law is still on the books.
And it could have been repealed at any time.
Could have been appealed, or the judge could have ruled that it was unconstitutional. He didn't rule it was unconstitutional. He still ordered the president to return these individuals and give them a due process not in that law.
It's the law of the land. I think the president has the right to use it to protect American citizens. And with that, Madam Chair, I yield.
Thank you, Mr. Scott. I want to thank our witnesses again today for coming before us. And without any further comment, the witnesses are excused. I now welcome our second panel, Chairman Stile and Ranking Member Morelli from the Committee on House Administration. Your full statements will be submitted for the record, and we ask you summarize your statement in 5 minutes. Chairman Stile, I welcome your testimony.
Thank you very much. Thank you very much, Chairwoman Fox, Ranking Member McGovern, members of the committee. Thank you for inviting me to testify in support of H.R. 22, the Safeguard Americans Election Voter Eligibility Act, known as the SAFE Act. I also want to thank my colleague, Mr. Chip Roy, for his sponsorship of this bill and his collaboration in working to get this legislation into final form. Also would like to thank Speaker Johnson and his team and the committee for all their time and resources dedicated to bringing this bill to the floor. As the chairman of the Committee on House Administration, I'm focused on securing our elections. We've held numerous hearings on election integrity and spoken with election administrators and experts on federal election law from across the country. This bill, the SAVE Act, passed the House of Representatives during the 118th Congress with bipartisan support. But unfortunately, it was not taken up by our colleagues in the Senate last Congress, so I'm pleased to see the SAVE Act brought to the floor once again. The SAVE Act will help restore Americans' confidence in our elections. Through the SAVE Act, we'll strengthen our election administration and keep American elections for American citizens. In recent years, we've seen a growing number of jurisdictions across the country allow non-citizens to vote in municipal elections, including right here in our nation's capital. In Washington, D.C., a non-citizen only has to reside in the district for 30 days to be eligible to vote in municipal elections. You can imagine what it would look like if that policy was adopted across the country. The SAVE Act contains critical reforms and strengthens current laws by requiring documentary proof of U.S. citizenship to register to vote in federal elections. 2 months ago, I held a roundtable with secretaries of state from across the country to discuss difficulties they encounter while administering the most recent election. One of their top concerns was the integrity of voter rolls, and we discussed preventing non-citizens from voting. The SAVE Act contains crucial reforms to election law that will help states conduct free and fair elections. The National Voter Registration Act currently requires states to give voter registration forms to everyone who receives a driver's license, regardless of citizenship. So, for example, in Illinois, non-citizens can obtain a driver's license, and under the NVRA, these non-citizens are given voter registration forms. And just a few years ago, Illinois had to remove hundreds of non-citizens from its voter rolls. All an application has to do is check a box saying they're a citizen, and the citizenship verification process is over. It's almost hard to believe. But following the 2013 Supreme Court case, Arizona versus Intertribal, the NVRA, as it's currently written, actually prevents states from asking applicants for confirmation of citizenship in federal elections. That's wrong. The SAVE Act would change the federal language under the NVRA to require and assist states in obtaining documentary proof of citizenship in person when an individual registers to vote in a federal election. State DMVs can no longer take someone's word for being a citizen. The self-verification method of claiming to be an American citizen does not ensure that American elections are secure. States have tried to enforce documentary proof of citizenship, but the requirement has been shot down by the courts due to preemption. And so the SAVE Act would require states to set up a program to remove non-citizens from their voter rolls. In order to assist with this process, the bill would give states free access to federal and state databases with citizenship information. By allowing this access, states can strengthen registration processes and ensure that non-citizens are not registered to vote. This has routinely been a top request made by secretaries of state across the country. The SAVE Act will direct the Election Admission Commission to update any guidance associated with the bill. That's an important point that we'll probably talk about here today. The SAVE Act will also ensure that states with same-day registration can comply with the bill. And finally, the SAVE Act is in line with President Trump's recent executive order on preserving and protecting the integrity of American elections. Many of my colleagues may say that non-citizen voting is already illegal. That's true. In fact, it's illegal for a non-citizen to vote in a federal election. This bill is about enforcing our laws and ensuring non-citizens cannot vote. So it's illegal to evade Border Patrol and illegally enter the country. It was illegal under the Biden administration, and it was illegal today under the Trump administration. But why have we seen the dramatic drop? Because of enforcement. So this bill is not simply about altering the law. It's still illegal for non-citizens to vote in this country in federal elections. This bill is about enforcing the law and getting the result we want, which is that U.S. citizens are the only individuals that are voting in U.S. elections. So I look forward to our conversation today. I think we need to pass the SAVE Act. And Madam Chair, I yield back.
Thank you, Mr. Stile. Mr. Morelli, you are recognized.
Thank you very much, Madam Chair. It's nice to see you. Thank you to the ranking member, Mr. McGovern. Thank you to the members of the committee. I'm grateful for your service on this committee, which I know takes a great deal of time. As an alum of the committee, it's always good to be back in the room. On the first day of this Congress, Republicans included the SAVE Act in the rules package under a closed rule. Yet here we are debating a bill that Republican leadership could easily have brought to the floor at any time. So I do have a simple question, which is, what are we doing here? Aside from process, however, I want to be crystal clear about the substance of the bill. The SAVE Act, coupled with the president's recent executive order, would cripple American elections. The SAVE Act and the president's executive order form the most significant effort to disenfranchise American citizens in this nation's long history. The SAVE Act would force American citizens into a paperwork nightmare, turning every voter registration into a bureaucratic tsunami of government red tape. The SAVE Act requires every American citizen to show generally either a passport or their birth certificate to register to vote. Want to use your real ID? You cannot. Even as my good friend, the distinguished gentleman from Wisconsin, admitted to this committee last year, most real IDs alone cannot be used for voter registration under the SAVE Act. Military IDs alone will also be insufficient to register to vote. You can use your birth certificate alongside your photo ID, but almost 70 million American women, a quarter of the citizen voting age population, have a different name on their birth certificates than on their ID. Most married women, 84% to be exact, change their name. This provision would also disenfranchise survivors of domestic abuse who have changed their names for safety reasons. That Republicans would willfully make it harder for domestic abuse survivors to vote is shocking. The SAVE Act will disproportionately burden rural Americans. It will force millions of rural voters, many of whom now register to vote online or by mail, to travel significant distances to present documents to government officials. Candidly, under the SAVE Act, voter registration, as we know it, ends. The SAVE Act does let Americans to use their passports to register, but half of all Americans do not have a passport. And a passport costs $130 per person plus additional fees. So the cost of the SAVE Act to American voters who are without a passport and need one to register, if they all did it, $19 billion. That's right, at the time of rising costs under the administration we currently have in the White House, with a looming Trump recession on the horizon, Republicans are trying to charge U.S. citizens billions of dollars just to register to vote. Let's face it, Republicans have one real purpose here: to weaken American confidence in elections, which Americans generally assume they have confidence in the election system. Just look at the recent executive order on voting. The order, like the SAVE Act, disenfranchises women, rural voters, military voters, Native voters, seniors, students, survivors of domestic abuse, and survivors of natural disasters who, after a flood or hurricane, may find it very hard to find documentation like their passports or their birth certificates. Worse yet, the executive order forces states to let Elon Musk and Doge into state voter databases containing personal private information. And I ask, why does Elon Musk need access to American citizens' voting records? I think the sole objective here is to scare Americans into falsely believing that non-citizens are voting in federal elections. But we know this simply does not happen. Last Congress, our committee held hearing after hearing on a number of topics, including non-citizen voting. But my colleagues could not produce any evidence to back up their claims, nor was there any evidence of non-citizens voting in the 2024 election. In fact, Speaker Johnson admitted publicly he had known proof of non-citizen voting in federal elections, thought it was simply intuitive. Well, we need to have evidence of it if we're going to make all of these changes. In fact, the SAVE Act does not solve any problems American elections do face, from chronic underfunding to state and county boards of elections, to violent threats against election administrators and election workers. The SAVE Act will not lower the cost of living for American families. Instead, will make Americans' lives more expensive. The press has extensively reported that some House Republicans have been afraid to face their constituents at town halls. The SAVE Act proves that in some cases, Republicans are also afraid to face constituents at the ballot box. They'd rather stop them from voting and registering altogether. But the American people will not fall for it. We should not approve this bill. And with that, Madam Chair, I yield back.
Thank you very much. I appreciate both of you being here. Chairman Stile, as you know, increasing the role of the federal government in state elections is something that should be avoided. But the SAVE Act simply amends established law on this subject, correct? It doesn't increase the role of the federal government, but closes a fundamental loophole that exists in current law. Is that correct?
That's exactly right. In many ways, Congress broke this, and Congress needs to fix this. And so as we discussed under current law, National Registration Voter Act, states give registration forms to everyone who receives a driver's license. I was not here when that law was written. When it was, maybe people didn't think states were going to be giving driver's licenses to illegal immigrants. Maybe they did. But in the case of a non-citizen receiving that as required, it sure seems like an area to me that Congress should engage in fixing the law. So Congress broke the law when they wrote it originally, and this is our opportunity for Congress to fix that law.
Short follow-up. Is it your view that the participation of non-citizens and illegal immigrants in our voting processes has been increasing in the last decade?
Well, we do know that there's a significant number of illegal immigrants that entered this country during the Biden administration. There's also legal immigrants in the United States as well. And so we have seen this occur. There's a series of documents and evidence that we put forward in our committee through different hearings where this has been the case. My standard is that one non-citizen voting in U.S. elections is too much. I know some of my colleagues on the other side, their standard is higher than that. We can have that debate on the House floor when this bill comes forward. But this bill really allows the true enforcement of the law that is in U.S. elections only U.S. citizens can vote.
Thank you. And we have a member serving currently who won her first election by only 6 votes. And so to say to discount anybody voting illegally really is unjust, because if you're winning by 6 votes and you had, hypothetically, 6 illegal or ineligible voters, then that distorts the entire program. And 6 votes is not much. And it's not hard to see that when you're seeing 400, 500, 600,000 votes cast. So thank you very much again, Mr. Stile. Mr. McGovern, you're recognized.
Thank you. Just a few questions. First of all, I'm trying to understand kind of why we are here right now. If I remember correctly, in our opening day rules package, we provided a rule, a closed rule, because that's what you guys all like, is closed rules, to deal with the SAVE Act. Is there a manager's amendment that you're bringing to us today, or is there something new from the bill that was that we gave a rule for in the opening day rules package, and now is there any different language?
This is the same bill and the same text that we passed last year.
Why are we here? You already have a rule to bring it to the floor. Why are we bringing this? Why are we here having a debate about another rule?
I would, if it's directed at me, Mr. Ranking Member, I would defer to the Rules Committee for the expertise as to the rules process, but happy to comment on the substance of the bill.
But didn't you ask for there to be a rule granted for this, a new rule? I'm just wondering, why are we having a new rule when you already have a rule? It's the same rule. This will be a closed rule as well, I'm assuming. So, like, I'm just trying to, why are we having this second meeting to take up the exact same bill and give it the exact same closed rule?
Again, I would defer to the Rules Committee as it relates to that process. Obviously, the Rules Committee.
I have a theory. And I have a theory that you guys are trying to derail the discharge petition that Representative Luna brought before this chamber. I want to request, I have unanimous consent request to insert into a record a letter from Representative Luna announcing her departure from the Freedom Caucus. And Representative Luna writes, and I quote, "When compromise proved impossible, our own Freedom Caucus members on the House Rules Committee and a small faction of our group advocated to change our rules of governance by tying my petition to a rule that would kill it and attaching it to the SAVE Act." And I also want to ask unanimous consent to insert into the record a letter from Representative Luna regarding Speaker Johnson's efforts to use this committee to kill her discharge petition related to proxy voting for new parents. And she writes, let me quote the letter that she is sending to all the Republican conference. She says, the speaker is being blackmailed. The speaker is being blackmailed into doing this. But this behavior to force someone into doing something is categorically wrong and everything we're supposed to stand against, end quote. So
without objection.
Yeah, so is that the reason why we're here? Is so that we could so that we could try to get a rule that might make it more difficult for Republicans to vote no on in order to kill a discharge petition where a majority of members of this House, Democrats and Republicans, signed onto, to be able to bring a debate and a vote to the House floor on proxy voting for new parents?
From the rule standpoint, I'll defer to the expertise of the members of this committee,
I don't know.
It's not the jurisdiction of the Committee on House Administration.
But you asked for this. You asked for this in a letter you sent to this committee. You asked us to give your bill a rule, and I guess I'm just puzzled by we already gave it a rule. We already gave it the kind of rule that you want today. So I mean, this is kind of a scam to derail a discharge petition that some of your members, many of whom, by the way, when we had proxy voting, utilized proxy voting, including the Speaker of the House, by the way, but now want to deny new mothers the ability to participate in voting. I mean, I think we all know that's what's going on. Nobody wants to talk about it. Everybody wants to make believe it's not happening, but we all know what is happening. Ranking Member Morelli pointed out that almost 70 million American women have a different name on their birth certificate than their photo ID. And under this bill, they will be unable to prove citizenship using a birth certificate. So they would need like a passport? Would that be sufficient to prove that you're a citizen?
Directed to me?
Yeah.
No, actually, I think page 14, line 19, actually explicitly addresses this and directs the states to create a process for addressing this exact issue. Name changes are state-specific, and so each state, your state and my state, may not have the same process for an individual to change their name. And so therefore, in this text of the bill, we've explicitly asked the states to design that process to make sure that individuals are not disenfranchised.
But how many different ways could you design a process to address that short of a passport?
Can I give an example?
Yeah.
So we could look, for example, to the state of North Dakota, which uses Real ID and indicates citizenship on those identifications. So an individual in the state of North Dakota, when they obtain a driver's license or any other form of ID, would have a citizenship or non-citizenship delineated on their driver's license, and therefore would be able to utilize that. That'd be one example.
But as you know, a lot of Real IDs don't require proof of citizenship, like in D.C., for example.
And so we would look for many of these states or in
so
the case of...
if you don't have to prove proof of citizenship for a Real ID in many states, and many states don't have Real ID, then what are your options? You have like a passport. And you know how much a passport costs?
Well, a passport would be one of a series
of options. It says $160.
But it would only be one of a series of options. And so, for example, any given state, as we note in page 14, line 19, directing the state to create a process for addressing the exact issue, the state could make obtaining a license free in their respective state if they so chose, or they could charge an amount depending on what each individual state determines to set up as their process.
So could the state not change anything and keep it as it is?
North Dakota would be just fine. Yes, sir.
I mean, could every state just maintain the status quo?
It depends if they're in compliance. I would need an example of the state. I'm noting that North Dakota would be in compliance today.
Right. Well, but I'm just simply saying, in order to prove your citizenship, if you're a woman and your name on your birth certificate is different, I'm just I mean, the state's coming up with the criteria. What would that? I'm trying to think of the criteria that wouldn't cost a lot of money, or that wouldn't be so difficult that it would dissuade people from voting. It just seems like the brunt of all the requirements in this bill are on women. Mr. Morelli.
Well, I do want to point out that, first of all, the executive order by the president gives no instruction at EAC whatsoever. So that's obviously at odds with the bill that is being advanced here today. But I'd also note that the act becomes effective immediately. It's upon enactment. If you then charge the 50 states with coming up with, after getting guidance from the Elections Assistant Commission, so once that happens, they will provide whatever guidance and then send it to the states, and the states will have to make decisions, presumably similar, maybe different requirements in each state during that entire time. And that could take months. Women who have a different last name by virtue of being married, and 84% of women take their husband's name in America, they will be unable to register to vote. So that could take months and months. There's no way to register during that time.
Do you want to add something?
Sure. We're looking at a federal election that's 18 months away. So if enacted immediately, you have the 18 months. There's not a federal election nationally in the interim. We note that states will be creating a process to address this issue. So if a state wanted to put forward, you could bring your marriage license and show other documentation of the name change, for example, a state could put that forward. As it relates to the finances, that any given state chooses what those fees are associated with of obtaining something such as a marriage license.
If I might, that's not entirely, I appreciate my good friend, the general election for the 2026 election, but we have special elections going on right now.
Right, yeah.
There are vacancies in Texas, there's 2 vacancies in Florida, and there certainly could be other vacancies that would occur. But this is, and by the way, this isn't about voting, this is about registering. So you'd have to wait months to figure out what your state does after you've waited for the EAC to come up with guidelines that would be implemented. So for a period of time, and it could take months, women who have a different last name than their husbands or than their birth certificate, by virtue of taking their husband's name, will not be able to register to vote.
Yeah, I mean, this sounds like a
They
hell of a
won't
lot
be
of,
able to.
this sounds like a hell of a lot of paperwork just to be able to register to vote. Mr. Morelli, can you just talk a little bit more about how this bill will make it harder for members of our military to register to vote?
So if you're overseas, this will effectively end voter registration by mail, this bill. So you cannot do it unless you're physically present at the Board of Elections. Now, you could mail in a form, but you'd still have to go to your local Board of Elections to bring your documentation. So you could mail it in, but it wouldn't be effective because your documentation will have to be brought in. So if you're serving overseas, you're a Marine somewhere stationed around any place in the globe, you can't register by mail. If you haven't registered before you get deployed, you simply can't register to vote. So think about it. Men and women who are literally putting their lives on the line to defend the rights and interests of American citizens would not be able to register to vote in an American election. It seems like the greatest insult of all. I'd also mention, as it relates to senior citizens, if a mother or grandmother of yours is in a nursing home, they have to re-register because they're changing location, but they can't mail in their registration any longer. So 90-year-old person who's incapacitated, living in a skilled nursing facility, they somehow have to get to the Board of Elections. They have to make sure they have their birth certificate. They have to have a passport. If they have a different name than their birth certificate, they're going to have to get documentation. Of course, they'll have to wait for that to get approved. Same is true. I mean, you can list person after person after person. This will create such a dynamic and honestly, for many things that you might have to provide documentation, like I have Real ID.
Yeah.
I just went last week to get my enhanced Real ID required under the state of New York. Turns out I didn't have the documentation I thought I needed. I went home. I'm incredibly organized. I couldn't find it. But to get Real ID, I'm required. So I'll have to go through a process to get replacement documentation. I'll do it. But if it was just simply to register to vote, you might say, yeah.
This sounds like a voter repression, a suppression bill. That's what this sounds like. The last election, I mean, supposedly all these illegal aliens voted in the last election. Donald Trump won. Maybe were they all Russians? I don't know what happened. But the bottom line is, I expected my Republican colleagues to do something like this had Kamala Harris won. But this is a little bit, over the top. But I want to ask you unanimous consent to put a letter from Mr. Stile into the record where he asks for this committee to grant a rule on the SAFE Act. And Mr. Stile, I would ask you not to send us requests in the future if it is not your request or if you don't know why that you're doing it. Bottom line, we're here because you asked us to give this a rule. I asked you what's different from the bill that we gave you a rule on in the original rules package to now, and you told me there's no difference. I don't know, it seems like we're wasting our time here.
Well, it should be maybe then an easy yes if we already have the ruling. Give us the ruling.
No, well, I mean, you have 9 here, you'll get a yes, but it's like, I mean, it goes back to what I'm saying. What this is about is it is about shutting off the discharge petition. It's the first time
Mr. McGovern.
that we have done something like this, and you were party to it, and with that, I yield back.
I believe the gentleman knows that every time there is a bill before the committee, the chairman of the representative committee will send a letter to the committee asking for a rule. With that, I recognize.
Thank you, Madam Chair. And I would like to call this a voter protection bill as opposed to some of the names that has been called by the other side. And Mr. Stile, I know that the other side's claiming that we are disenfranchising, doing all kinds of horrible things, and particularly for veterans, married women, and some other that may have lacking some documents. But this bill actually requires states to protect the voting rights of these folks that we're talking about. Isn't that correct? And maybe you could explain that a little bit.
No, absolutely. And I think it goes to the core principle that if a illegal vote is cast, it cancels out the vote of a legal vote. And so if we have a non-citizen who votes in an election, that cancels out the vote of a legal citizen. Chairwoman Fox noted correctly that we have a member of Congress who won her respective race in Iowa by 6 votes. We have indications in some states where hundreds of people have been added to the voter rolls who are non-citizens. If those individuals cast a vote, they could decide a House race. Often in the House of Representatives, many of our races are incredibly close, decided by a few hundred, or in this case, 6 total votes. And so making sure that we are enforcing the law to make sure that only U.S. citizens are voting in U.S. elections, I think is absolutely appropriate.
Yeah, because I think you mentioned it earlier, one non-citizen voting is too many. And so I appreciate that. But I did want to I know that there was some discussion earlier about the about state IDs and things like that. And I am from a state that will issue state IDs to anyone who, regardless of citizenship or legal status, anything like that. And so it is a serious issue. And I know that there have been reports in Minnesota of non-citizens being mailed ballots, because then we have the ballots just being mailed out. And so there's a huge concern about this. And I recognize that, we shouldn't be, the federal government shouldn't be, we should be very careful about what we do in elections. And I think this absolutely assists in making sure that our elections are secure. So I thank you, and I think I'm supposed to thank Mr. Roy for bringing it forward too, and thank you for handling the rules portion of it. With that, I yield back.
Thank you, Ms. Fishbach. Ms. Scanlon, you're recognized.
Thank you. I don't know how many times I have to see this bill, but between judiciary and rules and House floor, here it is again. It's a terrible bill. It's not about solving real problems, but about solving or spreading misinformation, weakening confidence in our elections, and making it harder for eligible voters to, in fact, vote. It's a dangerous bill because it would keep millions of eligible voters off the rolls under the false pretense of addressing a non-existent problem. I think it's notable that when the chairwoman asked the chair of House Admin whether the incidence of non-citizens voting had increased in the past decade, he did not answer that question. He talked about some other things, but he could not say that non-citizens are voting in larger numbers now than they ever have in the past, because in fact, there is no evidence that non-citizens vote in any appreciable numbers. And that's what we've gotten from all of the evidence that has ever been submitted. But if you think about it, if you are a non-citizen and you go register to vote, and then every time you vote, you are providing evidence that you are doing something illegal that can get you deported, that can get you jailed, and can get you fined. That, among many other reasons, is why non-citizens don't vote. So it's a non-existent problem. Every state has procedures in effect to make sure that only citizens are being registered to vote. So the real purpose of this bill isn't to protect elections, but it's to suppress voting. We've already seen what happens in my state, in Pennsylvania, when you put these kind of onerous documentary requirements on registration and identification for voting. It means that certain people aren't then able to vote, even if they're eligible to. And this act in particular, as the ranking member has pointed out, has a particularly harsh impact on women because of the number of women who change their names when they marry and then don't have a birth certificate or other documentation showing citizenship that matches their married name. So I think the ranking member's point that this bill is supposed to go into effect immediately upon passage is worth teasing out a little bit here, because we've got the issue of it has no way for women to prove their citizenship. But let's look at this real ID requirement, because the two basic forms that this bill posits that you can prove your citizenship are a real ID that indicates citizenship. Only 5 states provide that. So Minnesota's one, New York's another one. Only 5 states do that. Pennsylvania doesn't provide that. Most of the states don't indicate citizenship. So that means as soon as this bill goes into effect, most people across the country aren't going to have real ID that meets the requirements of this bill. Again, in Pennsylvania, it costs $30 more to get real ID. I don't know what additional requirements might be added when they have to then go the extra yard to put a citizenship stamp on it. But it's more expensive to get a passport. It's more expensive to get real ID. Right now in Pennsylvania, only 25% of our citizens have real ID, and less than half have a passport. So that means that most Pennsylvanians who are eligible to vote are not going to be able to under this statute. I think it's really poorly thought out. It seeks to solve a non-existent problem, and it puts unacceptable burdens on eligible voters. Is there anything you wanted to add, Mr. Morelli?
Well, I just want to suggest that while people are suggesting this has to do with non-U.S. citizens voting, actually it just puts burdens on U.S. citizens.
Yeah.
And that's really what this does. And the burden is extraordinary. And so it's actually the opposite of what it said. And frankly, to your point, there's no evidence that there is a significant increase over the years in non-U.S. citizens voting. In fact, it's not only illegal to vote, it's illegal to register to vote if you're not a U.S. citizen. So, I mean, this is a lot of work. And this is truly billions and billions of dollars, new infrastructure that would be required at the state and local level. In fact, if you're a local election official and someone comes to you to register and you take information because you think it's appropriate when it's not, you could face 5 years in prison, felony charges, as a local election official. I mean, it's an extraordinary, I mean, I'm sorry the chair isn't here who said this is simply, the federal government doing what it's always done. It's not. This is an enormous intrusion on the states and local boards of election when we should be worrying about giving them enough resources to do their already difficult jobs and providing them with predictable funding over the years. We're not doing that, but instead we're going to build a giant infrastructure and create this massive bureaucratic solution in search of a problem.
Well, I think that is interesting because several of our Republican colleagues mentioned the fact that under the Constitution, Article 1, Section 4, the Election Clause, it is the job of the states to administer the elections. And they generally have first crack at all that. But here we have Congress imposing a huge bureaucracy to solve a non-existent problem. That sounds like waste and abuse. And I thought this administration and the Republican majorities were against waste and abuse, but this is billions of dollars of it. I would just close. I think the ranking member put in one of Representative Luna's letters in which she says, the Constitution entrusts us to serve, not to twist rules for power or to silence dissent over petty disagreements. When we abandon that duty, we weaken the foundation we swear to defend. I urge you to reject these tactics and stand for a Congress that supports its members and our nation's future. I think that also applies to this bill. Seeing that there's an attempt to twist the facts and twist the law in order to suppress votes, I think that's an abandonment of what we're here to do. I yield back.
Mr. Griffith.
Madam Chair, I just wish I could get my colleagues on the other side of the aisle to adopt all of Representative Luna's philosophies, and we'd be a lot better off. That said, I have long supported this both in the committee, not just the Rules Committee, but in the Admin Committee, and now here in Rules. And so, without further ado, and not wanting to waste or abuse the committee's time, I yield back.
Thank you. I would call on Ms. Ledger-Fernandez.
Thank you very much. It is interesting of why we're here again, because it's sort of like, we could call it Groundhog Day, but it's not, because this is a very different day, because we are dealing with the same bill, but the reason why we are here is very different. And I think that is very clear with Representative Luna's letter. And if that's not the case, then we'd have a clean rule. Then our rule that we come out would not mention the discharge petition at all. Have you asked for there to be any issue in the rule with regards to the discharge petition, Chairman?
I'm fully supportive of the SAVE Act. I've looked for the SAVE Act to come to the floor. I'll defer to the Rules Committee as to the
You're going to be deferring
rule.
to the Rules Committee. This is, the discharge petition has nothing to do with the SAVE Act. So if we see anything about the discharge petition, we really know why we're here, and I think we're going to see that. And what's also interesting about a rule that might come out attacking the ability to do a discharge petition is the whole after the fact, right? Representative Luna thought there was a process. If you want to get a discharge petition, do the work. Get on the floor, convince your colleagues to sign that discharge petition, have them put their names in signature in ink. And if this committee, with these Republicans, pass something that takes that away, they are changing the rules after the fact. And if I were Representative Luna and everybody else who signed that discharge petition, I agree, they should be mad. What are the rules of the House? Do we know what they are? Can you just start changing them willy-nilly anytime you don't like what people are doing? And that's kind of what this committee does do. But Chairman Steele, going back to this bill, to your knowledge, when did the Ho-Chunk, the Chippewas, the Menominee, the Oneidas, and the Mohicans first start living in Wisconsin?
Before the founding of our country, to the best of my knowledge.
Yeah, 17th century, time immemorial, a long time, right? And because of that, long history that the first Americans, people who have been living here since the beginning of the country, Wisconsin, New Mexico, and almost every, not every, but almost every state with significant tribal membership allows a tribal ID by itself as proof for registration. But the SAVE Act does not allow a tribal ID by itself as proof for a citizenship. And I don't know about you, Chairman Stile, but I worked with tribes for 30 years. I have yet to meet an undocumented immigrant trying to vote with a tribal ID. It just doesn't happen. The first Americans, they've been here. But also I want to go back to this concept of what you said earlier about if just one undocumented immigrant, somebody who's not a citizen votes, that's too much, right? I'm thinking about all the women who won't be able to register and vote. So for that one undocumented, you're willing to sacrifice. In New Mexico, maybe about 431,239 women who have a name that doesn't match their birth certificate. Nationwide, 69 million married women across the United States have changed their name, and so their birth certificate would not match up with their legal name. I'm assuming you know how many women in your district have names that don't match their birth certificates, Mr. Stile.
Again, page 14, line
Page
19
14.
directs the states to create a process to address the exact issue you're identifying.
Page 4, but no, that's not the problem. The thing is that we don't know what Wisconsin will do. We don't know what New Mexico will do. We don't know what Utah will do. And so what you are creating is a problem that then will need to be solved. Right now, this bill is trying to solve something that doesn't exist. And you are creating a problem for women across the country, because then women are going to be at the mercy of what does their state do. So New Mexico, we believe in voting. We like it when people vote. So we will pass whatever we need to make sure that women can vote. But we don't know what they'll do in Texas. We don't know what they'll do in Utah. And so it will depend on which state you happen to live in, whether if you're a married woman, you'll be able to register to vote without buying, and it is buying, that passport, right? You said, how much does a passport cost? Do you remember, Chairman Stile?
I don't have the number in front of me, but it's over $100.
It's $130. But you know what? When you want to get a passport for $130, you're going to have to wait 4 weeks, 2 months before you ever get that passport. And you know what? With Musk and Trump firing everybody, that 2 months to 3 months that was too slow already is going to take even longer. And so when you'd be able to do this is going to be unknown. And Ranking Member, I mean, your point about how much it would cost Voting is supposed to be free, isn't it?
Well, I mean, I think voting is essentially one of the basic inalienable rights. I mean, it's what makes America America, is our right to participate in self-government, and we should want elections to be free, fair, and make sure every single individual has their vote cast. So, yeah, this is a right. Yeah, I mean, when you have not a privilege but a right, and you have to spend $130, $150 just to register, if you can get there. I mean, if you're in a rural community, you may have to travel 3-4 hours just to get to the Board of Elections. So you add the gas costs, you add, to your point, if you have to get a photograph, if you, I mean, depending on what you have to do to get the documentary evidence together, it's certainly going to cost you money. And frankly, you don't have to pay for your freedom to speak, your freedom to assemble, your freedom to worship.
You shouldn't have to
and
pay
you
for your
shouldn't have
freedom.
to pay to vote.
Shouldn't have to pay for your freedom of vote. But everything that Trump and Musk and the Republicans do seems to be costing us a whole lot more. And I need to tell you, women can't afford Trump, and they can't afford to pay $130 or $190 to get a passport so they'll be able to register the vote. And, you know, Representative Steele, there are 162,000 women in your district, 167,000 in Representative Van Orden's district who might not be able to register to vote in upcoming federal elections without a passport. And, you know, I just don't think that's right. And the idea, you responded to a question that this doesn't overturn any state law. Well, I pulled up Wisconsin state law, and Wisconsin state law has a long list of identification that you can use to register to vote, including tribal ID. And it actually makes sure that the military will be able to register to vote. So I would argue that it does overturn state law because it is changing what Wisconsin can do with regards to who can vote. And then, you know, this idea that there's no evidence, right? When you were asked, what evidence is there? You talked about evidence of immigrants coming into this country. That's not evidence of immigrants voting. Ranking member, there were lots of hearings on this. What is the evidence with regards to undocumented voting?
Well, as I said, even Speaker Johnson indicated he didn't have any evidence that he felt intuitive that people were voting who were not U.S. citizens. But I would just, again, we had, I don't know, probably 10 different election-related hearings that weren't all on the question of U.S. citizenship, but many were. And there was no evidence brought forward that indicated this had happened. And so I would just continue to say this is a pretty costly bureaucratic nightmare of a solution looking for a problem. And I do find it ironic, the complaints in 2020 that non-citizens had voted in federal election. That's why one of the reasons the election turned the way it did. But you didn't hear any evidence of that in 2016 or 2024. It seems like only non-citizens somehow managed to vote in elections that President Trump loses, not the ones he wins. It's just kind of odd how that happens.
Right. You know, and only 55% of women in Representative Stiles and most of the Republicans on this district, of the women in their districts have passports. You know, my district is very rural, only, you know, they don't have passports. 55% of the women in my district who are married don't have passports because they're working mothers. They, you know, they don't get to travel to France or to Australia or any of the other places. They stay home and they work hard. And so when you have that many women who don't have passports, that many women who have a different name than their birth certificate, you are setting up a process for married women to be able to register to vote that is onerous, that is expensive, and that is simply un-American. And with that, Madam Chair, I'll yield back.
Thank you. I just wanted to point out, too, I know that a lot's been made out of you asking, Mr. Stile, asking for a rule on this bill. But from what I understand, and I wasn't here, but there is precedent to do this. In July of 2020, on HR 553, the Democrats actually, in a rule, turned off consensus bill in the rule. They turned it off, and it was a Joe Wilson bill, and so the Democrats, so there is precedent to do this and what we're doing in this, in the rule, from my understanding. But I just wanted to point that out because I know much has been made of that. And I would call on Mr. Norman.
Thank both of you for taking the time to be here. Congressman Steyer, wouldn't you say that, you trust but you verify?
100%.
And if we lose our integrity in voting, that we've basically lost our representative.
You need to have integrity in voting.
And wasn't this all highlighted when the Biden administration opened the borders to over 15 million illegals coming in this country?
That's why I think a lot of people woke up to the risk of non-citizens voting. I mean, previously it was mentioned that there's no existing problem, and that's just not true. We could actually go all the way back to 1996, where there was a contested U.S. House of Representatives race in Orange County. A congressional investigation in that case found that 624 non-citizens voted in the race. They'll go back and say that this or that, or they found somebody that wasn't a citizen in that. Then we could go look at Fairfax County in 2011, where Virginia found 278 non-citizens on the voter rolls and over 100 voted. We could look at the Chinese citizen in the state of Michigan who cast a ballot in the previous election, and once that ballot is in the hopper, so to speak, you can't get it back out. You poison the well. And so what we're looking at here is how do you enhance and increase the integrity of U.S. elections so it's for U.S. citizens only?
And it just wasn't the ones you mentioned. In Pennsylvania, they admitted that a few years ago it had inadvertently allowed 10,000 non-citizens to register to vote. In Texas, had a problem where 100,000 non-citizens registered. In Illinois, hundreds ended up on the voter rolls. Ohio said it was removing 100 non-citizens. Georgia found an audit that 1,600 non-citizens had attempted to register to vote. Now, how is that not proof?
It not only is it proof, it's occurring. We have the individual from China who admitted to having voted in the previous presidential election in the state of Michigan. But I think what we're talking about here is how do you make sure that this isn't occurring in the first place and putting in rules of the road to fix it. But in particular, Congress broke it. So Congress wrote the NVRA in a manner that really was giving out voter registration when people came to get a driver's license. And when they wrote that, I think there was a mindset that states were only giving a driver's license to legal U.S. citizens. But as we know, in states across the country now, driver's licenses are provided to illegal immigrants. And that has been exacerbated the problem, which really I think is where you opened there, Mr. Norman, talking about has this problem been exacerbated? Well, it's exacerbated because we know a large number of states across the country are giving voter registration forms to non-citizens because they're actually required by federal law under the NVRA to provide that documentation. And so what we're saying is let's go in and amend the NVRA, but let's get it right this time so that there's evidence an individual is a citizen of the United States when they register to vote.
I think the illegal immigration is probably the primary factor. Donald Trump's approval ratings are through the roof now. And the fact that, the number one question I had in citizens in South Carolina, why is the Biden administration doing this? We've never seen this. And it had to be for one or two reasons. Either he felt sorry for 15 million illegals and just wanted to give them access to everything America provided, or he wanted to create a power base of votes. That's the only two, and I don't think it was from the he felt sorry for them. Just let gang members in that have killed citizens, and the American people aren't putting up with it. Plan to support it. Thank you. You want to say something else?
Can I just add one more point, if I can, Mr. Norman, because we had a lot of conversation in previous questions about passports, and I didn't get a chance to rebut or comment as to why that's misleading. And it's misleading because passports are only one of a series of documents that can be used to show citizenship. So yeah, a passport does cost more, which might be a great reason why your state wants to issue photo identification indicating whether or not you're a citizen, why you might look for other avenues, and why we set up in this bill an opportunity for states to put forward a framework for additional types of ID in addition to a passport. So yes, a passport does cost a substantial sum of money for individuals, which is exactly why we're looking at making sure other opportunities are available, which they are in the bill. A lot of the rhetoric that we're hearing is the same rhetoric we hear as it relates to photo identification to begin with, and we have been able to overcome those arguments in showing why photo ID is so important in the first place. Thank you.
Ms. Morelli, do you want to say something?
Yeah, thank you, Mr. Norman. But I would stress that only 5 states have real ID that have citizenship. I believe my state is actually one of them. So if you live in a state where real ID doesn't have your citizenship on your driver's license and you don't have a passport, you're going to struggle to find the documentation that suggests that you're an American citizen, particularly, again, if you're a married woman, because your birth certificate, even if it demonstrated that you were born in the United States, which would make you a citizen, if your name is different, you're going to have to somehow connect the dots for some poor election official who's sitting at the Board of Elections who doesn't even know if the documentation is right and who's going to fear basically being charged with a felony if he or she gets it wrong and accepts something that's not right, can face up to 5 years imprisonment for taking documentation that they assume this seems right and then find out it's not. This is really a very, I just urge people to read through the bill. Look, we could work on things that relate to U.S. citizenship. If that's the fear, I continue to suggest that most of these reported cases are not what they seem to be. We want to work on that, but someone should look at this and think about, get a big whiteboard and write down what would have to happen in your state or the various 50 states to be able to register to vote. It's going to be very, very bureaucratic. It's going to be cumbersome. It's going to make this very, very difficult to register. Anyway, thank you, sir.
Okay, I yield back.
Thank you, Mr. Norman. Ms. Houchin.
Thank you, Madam Chair. We've heard, frankly, some truly absurd things today, including the suggestion that this bill somehow takes away a married woman's right to vote. Let me ask this question. Even if voter fraud is not widespread, I hear this a lot. I worked on legislation in the state Senate for voter ID laws in Indiana. And from the left, we would hear, oh, it's voter suppression to require an ID. But how much voter fraud is acceptable, Mr. Stile?
No voter fraud is acceptable.
No voter fraud is acceptable, even one vote. Is that correct?
That's my view.
So how many married women is it okay to disenfranchise with an illegal vote by an illegal immigrant?
No one should be disenfranchised.
Mr. Morelli, how many married women is it okay to disenfranchise with an illegal vote by an illegal immigrant?
Well, the question is how many women being disenfranchised?
The question is how many married women is it okay to disenfranchise? That's the question. By an illegal vote by an illegal immigrant. Just an answer. How many? If the answer is not a number, then how many? Is it okay to disenfranchise by an illegal immigrant with an illegal vote?
I think it's wrong to disenfranchise any American.
Great, I agree. How many veterans is it okay to disenfranchise with an illegal vote by an illegal immigrant, Mr. Stile?
None.
Mr. Morelli, how many veterans is it okay to disenfranchise with an illegal vote by an illegal immigrant?
So I'll say again, you can ask me any category. It is never okay to
Great.
disenfranchise American citizens.
We agree. Mr. Morelli, would you support this bill if it had a requirement that a birth certificate was a proper form of identification? Yes or no?
I'm sorry, I don't understand the question. The birth certificate is potentially a form of identification, but if your name is different than your birth certificate, then you'd have a problem because you'd have to demonstrate the
like I do whenever I get married and I get a marriage license and I participate in the economy.
Potentially.
Right.
I mean,
okay.
Just to be clear, though, the marriage license is not in the bill.
I didn't say that, Mr. Morelli. I'm just saying that as a married woman, I did have to go through some steps to be able to participate in the economy and in elections and in all kinds of stuff, like changing my credit card information. I had to change my name at the Social Security Department. So there are lots of things that happen, and I think safeguarding our elections is pretty important. So
But I would
let me talk about
just to be clear, though, what you just said, if you had a marriage license, so if you have a birth certificate that has a name different than the name you have now, and you went to your board of elections, because you have to go there now in person, you can't mail it in. So you go and you have a birth certificate, and you have your voter ID, your driver's license. If you have a different last name, your marriage license may or may not suffice. It's not in the bill.
I'm not suggesting that the marriage license should be in the bill, but
okay.
since you brought it up, if a marriage license was an option in the bill, would you support it then, to require that as proof of citizenship to vote in our federal elections? Yes or no? You would not. Okay,
no,
so it doesn't matter.
I support the Freedom to Vote Act.
I'm going to reclaim my time.
Sure.
So it doesn't matter then, Mr. Stile, what's in this bill or is not. There are arguments about all these things that are or not in here really don't matter. The SAVE Act, to me, is a common sense pro-democracy bill that ensures only American citizens are voting in our elections, period. I think that's what we should all want to do. It strengthens voter integrity, in my view, by requiring states to verify citizenship before allowing someone to vote in a federal election. Many states offer already proof of citizenship as part of their voter ID laws: Arizona, Kansas, Alabama, and Georgia, and many other states. Even though there's some litigation surrounding that, courts have allowed proof of citizenship to vote at the state and local level. It's my understanding that some of this has not been allowed at the federal level due to confusion over the NVRA, which we're trying to fix now. So this bill, not only does it requires proof of citizenship, which I believe is a safeguard for our elections, it also requires that states clean up their voter rolls to give election officials the tools necessary to protect the ballot box. To me, that's not voter suppression, it's voter protection. And let's be honest, the American people overwhelmingly support this. They want fair elections. They want to know that their vote isn't being canceled out by someone who's here illegally. Chairman Stile, can you definitively set the record straight? Does the SAVE Act in any way prevent eligible citizens, including married women, from voting?
No, in this argument about the state process that we created, I think is worthy of just pausing and reflecting on. So we explicitly set forward the state process. Page 14, line 19, everybody can read it. Sets forward the state process. And the reason for that is because marriage licenses and some of these documents in different states are all a little bit technically different. So it's very logical in my home state of Wisconsin, which I'm more familiar with than maybe some of the other 49 states around our country, to recognize that they would allow the marriage license to be coupled with your birth certificate, and it'd be a pretty straightforward and unburdensome process. But what we want is each state to go through that, because the documentation in each state is different, as well as the cost of obtaining documents. In the state of Wisconsin, for many of these documents, the cost is low. That's not true in all of our states. And in fact, to get a voter ID in the state of Wisconsin, if you show evidence that you don't have means, you can obtain it for free. Totally appropriate mechanism. I'm supportive of that in the state of Wisconsin. We could allow the state of Indiana to set forward their path. And so it's actually intentional that we set forward the state path rather than in error in the bill. It's a mechanism to make sure that each state gets this right and prevents anyone from being disenfranchised. And if we think about that, if we go a little bit further, it's also worth noting, because there was some discussion as it relates to overseas voting, we explicitly are not amending UOCAVA. UOCAVA is a bill that's probably worthy of going back and looking at with modern technology. I'd look forward to working with all of my colleagues, Democrat and Republicans, as we work to have the option to modernize that bill. But the bill before us today makes no changes to UOCAVA and overseas voting.
Thank you. I appreciate your commentary. I think this is an issue of also federalism, letting the states decide how they're going to manage it. But I do think we should have a citizenship requirement, proof of citizenship requirement, before we allow voting in federal elections. Thank you, Madam Chair. I yield back.
Thank you, Ms. Houch. And Mr. Jack, you're recognized.
Just very briefly, I want to associate myself with the gentle lady's comments. My district wholeheartedly supports proof of citizenship with respect to voting. And the only question I have, just point of curiosity, Mr. Stile, do you believe that non-citizens should hold elected office in our country?
No. I believe the core of our democracy is that this democracy is based on U.S. citizens, and I think that U.S. citizens are the individuals that should hold elected positions.
Mr. Morelli, do you believe non-citizens should or should not hold elected office in our country?
Well, I don't believe non-U.S. citizens should vote in federal, state, or local elections. The rules of who can stand for election, I don't know. You may guess that's a question that I hadn't really contemplated, but I don't know how you'd serve and not be a citizen, so I'd say no.
Fair enough. With that, be mindful of our voting time. I yield back.
I had hoped to finish this panel before we went to vote because of the time constraints that we have in terms of voting, and because we have two members left to speak, unless they want to speak I believe Mr. Roy will want to talk longer than the time that we have. So I'm going to recess the committee until 15 minutes after the last vote. Rules Committee will come to order.
Madam Chair, may?
Mr. McGovern?
Yeah, I was not here when this was said, but apparently I was told that the gentlelady from Minnesota made some reference to the Democrats shutting off the discharge petition, and my understanding is that we turned off a consensus calendar bill that was later tucked into an NDAA bill. So that was done with the understanding that this particular measure would actually become law. So I just wanted that to be clear for the record. Thank you.
Thank you, Mr. McGovern. Mr. Neguse, you're recognized.
No comments. I'll yield.
Mr. Neguse yields. Mr. Roy is recognized.
I thank the chairwoman. Just a couple of things. First of all, Chairman Stile, there was an issue raised earlier about the ability for our men and women in uniform to be able to continue to register to vote, their engagement. Could you respond to that accusation and talk a little bit about UOCAVA and how that will continue going forward?
Yeah, this bill makes no amendments to UOCAVA. It's amending National Registration Voter Act. And so what we are noting is that some of the claims as it relates to our overseas service members, which we want to make sure have not only the right to vote, but the ability to implement that. There is a worthy conversation we probably have about UOCAVA. I think there's actual improvements that we could make in the bill to make it even better for our service members and address some of the other challenges we face. But the bill makes no amendments to UOCAVA, and so it's misleading to state otherwise.
I think that's an important point. And I would note, just for background here, because some of the questions have been raised about whether or not there are issues, whether this merits attention, right? That it's a problem that doesn't need to be solved. But is it not true that we've had significant amount of evidence and information of problems, including most recently, specifically indictments in Ohio for individuals, 6 non-citizens voting in federal elections. An Ohio grand jury indicted 6 non-citizens, which is this past fall. That seems like, okay, that's just a small number, 6. But to bring it to the level of indicting and bring it before a grand jury, right, that's representative of a larger problem at sample. Is that a fair characterization?
Yeah, not only that, but sometimes we have House races, as we noted with one of our colleagues from the state of Iowa, where she won by 6 votes. And so House races are often very close, where a small number of individuals could sway the election. Here you have an instance of 6 individuals that you just noted, and we know one of our colleagues won by 6 votes. So pretty easy to understand how a small number of individuals that should not be voting, who voted legally, could have a significant impact on the country in a particular period of time when we have a very narrow majority. A small number of races could easily determine the majority in the future of this country.
Now, and this reality is heightened by the most recent uptick in releases of individuals in the United States by the Biden administration, of individuals who are under various programs, through parole, through asylum, and the significant number of gotaways, right? So we're talking about millions of people, by the government's own counting, of people who've been released or have gotten away into the United States. Is that fair?
Absolutely.
And raises the specter and the concern significantly as a result. Is it not true that there's been a significant uptick in local jurisdictions, state and local jurisdictions, particularly local cities, including our nation's capital, in taking actions to register non-citizens?
Not only that, our nation's capital used taxpayer money to encourage non-citizens to vote. In the most previous election just a few months ago, we have a large number of non-citizens who voted in our nation's capital in municipal elections.
And did we not pass legislation last Congress to address at least the District of Columbia, right, where you're not dealing with the specific federalism questions? I mean, I can make arguments as to why we have a role to make sure that only citizens vote generally across the country, but specifically with the District of Columbia, right? We had 143 of our colleagues on the other side of the aisle who opposed a bill that we passed to overturn the District of Columbia's law allowing illegal aliens to vote in the local District of Columbia election. Now, 52 did support our colleagues on the other side of the aisle, but is that your understanding?
Absolutely. In the same way we saw a small number of Democrats who voted for the SAVE Act last Congress, but the overwhelming majority of our colleagues across the aisle clearly are on the record opposing the SAVE Act and opposing making Washington, D.C. a jurisdiction where only U.S. citizens are voting.
Mr. Morelli, and I want to be very careful. This is not a gotcha question. I want to give you a chance to kind of clarify the record, because you stated earlier your view about non-citizens voting in state and local elections. We had that vote, and I believe that you opposed that bill. I want to give you ability to explain that and the, apparent disagreement in that.
It's a fair question. I personally believe that you should be a U.S. citizen to vote in federal elections, state elections, local elections. Also respect the fact that the city of Washington chose a different route, and the question was whether or not we should impose on them, and I voted to allow them to continue to exercise what I think is their judgment, even if I disagree with it.
Okay, fair. I just wanted to be able to clarify the record on that.
Yep.
Is it not also true, because some things have been raised about how the process would work, that they say, well, the bill will be, it's enacted, and becomes law immediate upon passage, right, or being signed. But the truth is, those who are registered to vote would still be able to vote under their current registration, right? And that the only things that would change on that is to the extent that states, under their laws of cleaning their voter rolls, which the bill contemplates the need to clean the voter rolls, that they could enact requirements under their state laws as to how they wanted to proceed, and or any other circumstance that would change, right? So is that fair characterization? If you're currently registered to vote, you're going to be able to go vote.
This has no impact on individuals that are currently registered to vote.
Right. And so I said if there's an intervening circumstance. And so to the extent that there's an intervening circumstance, right, the bill contemplates the ability to present various forms of identification to register, right? Various forms that would include obviously a passport, and to the extent that not everybody has a passport, a real ID, to the extent the real ID is not adopted by every one of the states to have the citizenship status on it. We believe, right, that the structures put in place now that allow, I think there's at least 5 states that do have the citizenship status as part of their real ID, encourage more states to do so, right? That would be part of the goal here. And is it not true that there's something like 35, I don't get the exact number wrong, 35, 32 states that currently require voter identification in their own laws, under the state law? Is that correct?
That's correct, to my knowledge.
And so the idea here is that for individuals to be able to continue to vote if they're registered, if they have an intervening event, or if the states want to clean the rolls, people would come forward to register to demonstrate their citizenship, so we could convert our system over some reasonable time to a citizenship-based registration system, and to make that clear so there's documentary proof. And that we then, to your point, which you've now put out on the record multiple times, we have mechanisms giving the state fairly significant deference to make determinations as to how to structure the situation where an individual does have a name change, right? Which, of course, is often women, but it's not always women, right? There's men who change their names. There's, somewhat infamously, people like Chad Ochocinco, might be running around trying to figure out how to get registered to vote, change his name. And so we've got the ability to do that, though, right, through the processes specifically contemplated in this legislation.
Absolutely.
The other part that I want to point out here, you've mentioned the NVRA concerns. Is it not true that Arizona, for example, has 2 separate systems, right? Yeah. One system for their state and local elections where they check citizenship.
Yep.
But one for the federal where they do not, because they are prohibited under the NVRA, or I should state more clearly, they are prohibited under the interpretation of the NVRA from being able to get the information necessary to check citizenship as a state. So a lot of my colleagues have heard them say, well, the states can figure this out, but yet they can't. Isn't that true?
100%. There's a Supreme Court case on point on this that prevents Arizona from doing the things that are absolutely logical and reasonable to all of us sitting in this room. And so what Arizona has done is created a dual system, because they are blocked from checking for citizenship in the manner that they want to, in a manner that is absolutely reasonable. So they can only do that at the state side versus the federal side, so they're running a dual system.
Another important point, right, is that it is, if someone is in the pipeline for citizenship currently, and yet they register to vote illegally, that could prevent them from ever becoming a citizen, correct?
I believe so, yes.
So it's in the interest of all that we get this all done correctly to ensure that no one gets, registered to vote illegally, so that they're then prohibited from being in the citizenship pipeline if they followed all the rules and all the laws to therefore be in that pipeline appropriately. Is that correct?
Yes, and it's why the NVRA has such a significant error in implementation when you realize that states are required to provide voter registration material upon getting a driver's license. So it maybe sounded logical to somebody until we realize how many states are providing driver's licenses to illegal immigrants. And it's that point where people could get caught up. It could be a legal immigrant as well. In that case, who would be receiving documentation. So if a legal immigrant was in the United States, as you noted, going through the pipeline here legally in all other aspects, they'd still be provided with voter registration material at their point of getting their driver's license. That's illogical, and that's where your bill, Mr. Roy, is so important at cleaning this up.
And am I not correct, going back to the state and local voting last year, I think I've got a story that said there were 500 non-citizen residents of D.C. that have registered to vote in the primary election. That was data from last June.
I have 523 non-citizens registered to vote in the United States Capitol here in Washington, D.C. that are not only eligible to vote under current law in our nation's capital, they're using taxpayer dollars to encourage them to do just that, and many are taking advantage of it.
And to be clear, we passed a law to deal with that. Our colleagues on the other side of the aisle, 52, supported it. Some opposed it, but then it died in the Senate. Is that correct?
Yes.
There's some various litigation challenges to these things. Is it not true that the New York State's top court blocked New York City law to allow non-citizen voting?
That's my understanding.
So this is an ongoing matter of determination and litigation, even in a state like New York. Right?
Yeah, absolutely. We know the radical left wants non-citizens to be able to vote. They want to use Washington, D.C. as the petri dish in which they can roll that out across the country. It's all the more reason you need to have the SAVE Act in place.
So in short and in summary, this is legislation that would ensure that only citizens, American citizens, vote in American elections. There are multiple avenues by which we allow states to ensure that all citizens will be able to vote. They'll be able to use the proper documentation to do it, whether it's a passport or real ID or multiple other forms, allowing the states to make those determinations so that no one will be disenfranchised except for illegal aliens and non-citizens who should not be voting in our elections. Is that correct?
That's correct.
Will the gentleman yield for a title question?
I will yield to the...
I'm just kind of amused by all of this, but don't we already have a rule to bring your bill to the floor? Didn't we pass a rule in January to bring this to the floor? If this was such an urgent matter, why didn't we bring it up in January or February or March? Why are we here talking about this bill and having a whole nother debate on a rule?
Well, as the gentleman knows, we often have a number of bills in the first package of things that we bring forward through, and we're bringing things with the new House, and we run through a number of those things. Now this is one of those matters. The gentleman's own precedent is that when you start getting later in the year, you want to start coming through the Rules Committee, maybe even go back to committee. Yes, and yes, it is true that this bill did not go back to committee, but it was a bill that was passed last year, and so we're passing this bill through the Rules Committee, making very clear that it's important for this body.
Yeah, you already did.
I yield back.
You already did, and it's March. It's March, and there's no changes in this bill.
Gentlemen, yield it back.
I mean, this is a waste. Yeah.
Yield it back. I think
Yes. Thank you, Madam Chair. Representative Style, as has been pointed out, the National Voter Registration Act relies on individuals simply to attest that they're a citizen being able to vote. Should we really leave it up to the honor system with perhaps as many as 20 million people that have come into this country illegally in the last 4 years?
No, you should be required to show that you're a U.S. citizen. And in particular, as Mr. Roy was noting, the simple box checking mechanism of the NVRA is ripe for either abuse or mistakes. And so you could also envision an individual who literally makes a mistake. You could also envision somebody who's abusing the process, because once that box is checked, you're actually blocked from being able to follow up and require the documentation, which is the issue that we have noted the state of Arizona is trying to work around.
And we have Democratic cities all over the country. In my home state, New York City, tried this, and I actually led the legal challenge several years ago that now has finally prevented it from happening, where non-citizens are voting in municipal elections, and this could include, in a place like New York City, individuals from Russia, members of the CCP, and from other foreign actors adversarial to the United States. And on a federal level, we've seen attempts from non-citizens of foreign countries to vote in our federal elections. Is this not foreign interference in our election, Chairman Style?
I mean, it's the absolute risk of foreign interference. I mean, you could look at what takes place in Washington, D.C. under a legal system where an individual who works at the Russian embassy could leave that embassy, put their passport in their pocket, walk down and vote in municipal elections in our nation's capital, not even have to show the passport in their pocket because there's no requirement to show identification here in Washington, D.C. And so what we're doing is looking to set up a system that simply requires individuals who are voting to show that they're a citizen of the United States, to make sure that we're enforcing the law that only U.S. citizens are voting in U.S. elections.
And as I pointed out when I led that lawsuit, boards of elections claiming to have great intentions here to create a separate set of books for local elections from federal elections, and then there's even been an effort in my state to combine elections into the same year. So you'd have different tables perhaps for people to set up if they're going to vote for city council, but they have to vote for the presidency somewhere else. It's shocking to me that the same Democratic Party that claims to protect democracy is willing to jeopardize our democratic elections and institutions through welcoming foreign interference in those same elections. I look forward to supporting this legislation on the floor. I thank you for your leadership in this area. And with that, I yield back.
Thank you, Mr. Langworthy. Now, I believe everyone who wanted to ask questions has been able to ask questions. So I thank our panel members for being here tonight. I'm sorry we had to bring you back after votes, but we appreciate your patience with us and the work of the Rules Committee. You are now excused.
Thank you, Chair. Although, Madam Chair, I didn't get my question answered.
Mr. McGovern, I often have questions that don't get answered.
No, but it's a simple question.
I often have questions that don't get answered,
We just
Mr.
spent 2
McGovern.
hours on this, and we already have a rule for it. I don't understand.
I now welcome our third panel, Representative Barr and Ranking Member Waters from the Committee on Financial Services. Your full statements will be submitted for the record. And we ask you summarize your statement in 5 minutes. I'm going to repeat what I said. I welcome our third panel, Representative Barr and Ranking Member Waters from the Committee on Financial Services. Your full statement will be submitted for the record, and we ask that you summarize your statement in 5 minutes. Representative Barr.
Thank you.
Representative Barr, we ask that you summarize your statement in 5 minutes, and I welcome your testimony.
Thank you, Chairwoman Fox, Ranking Member McGovern, and members of the Rules Committee. Thank you for the opportunity to testify on SJ Resolution 18 and SJ Resolution 28. I offer my support for these resolutions of disapproval under the Congressional Review Act, which would nullify the Consumer Financial Protection Bureau's final rule aimed at imposing a price cap on overdraft services provided by financial institutions, and the CFPB's final rule targeting larger participants in general use digital consumer payment applications. These two midnight rules from the Biden administration's CFPB expanded the Bureau's power without sufficient justification or analysis. Both rules will stifle innovation and harm consumers by increasing costs and reducing access and availability of financial services and products. First, the overdraft services are essential for many American families. For those living paycheck to paycheck, paying a fixed fee to ensure that a payment, whether for groceries or diapers, is not rejected in the checkout line is crucial. These families understand the costs and willingly, and this is critical, willingly opt in to this service, finding value and convenience in that service. Instead of allowing competition to continue its beneficial effect, the Bureau has decided to intervene by reclassifying overdraft services as credit under the Truth in Lending Act, or TILA. This shift introduces burdensome disclosure and underwriting requirements for banks and credit unions. These requirements are both costly and unnecessary for short-term services like overdraft. The first option under the new rule forces financial institutions to treat overdrafts as extensions of credit, which of course they are not. This could significantly limit access to critical liquidity, especially for those who need it most. Requiring banks and credit unions to underwrite each overdraft, such as evaluating a borrower's ability to repay, is simply not feasible for such amounts. Additionally, TILA disclosures are more likely to confuse customers than to inform them. Moreover, the alternative option of justifying a charge higher than the $5 safe harbor will be nearly impossible for financial institutions. The CFPB will have the power to decide what costs are permissible when evaluating this charge, essentially setting a government-determined price cap. As a result, many banks and credit unions may simply opt out to charge a $5 fee or not offer overdraft services at all. This price cap would effectively price out high-risk consumers who rely on overdrafts, thereby reducing critical financial services and access. But the problems with the overdraft fee caps aren't just theoretical. The Federal Reserve Bank of New York has already concluded that, quote, overdraft fee caps hamper rather than foster financial inclusion, unquote. Furthermore, the claim that smaller banks and credit unions will not be impacted because the rule excludes institutions under $10 billion in assets is misguided. Smaller institutions will still be forced to lower their overdraft fees in order to compete and keep customers. Second, the larger participant rule is a textbook case of regulatory overreach. It stems from a flawed process and applies an overly broad approach that blurs important distinctions between very different products and services in the digital economy. The rule's expansive, ill-defined scope concentrates a diverse range of digital products under the generic label of general-use digital consumer payment applications. This includes peer-to-peer payment apps, digital wallets, e-commerce payment processors, and even certain embedded payment tools used in marketplaces and mobile platforms. These are not one-size-fits-all products. They serve very different functions. They carry different risk profiles, and they are used by customers in very different ways. Rather than tailoring its approach to the complexities of digital payments ecosystem, the Bureau issued a rule that treats all of these companies as if they're the same and deserve identical federal oversight. The bottom line is this: the Bureau had ample opportunity to develop a more targeted, risk-based approach, but chose instead a broad, one-size-fits-all strategy based on volume, not conduct, without clear evidence of systemic consumer harm or market failure. In fact, payment services accounted for only 1% of the Bureau's 1.3 million complaints in 2023. While the Bureau claims this rule is aimed at consumer protection, the real consequences will be felt by consumers themselves through higher costs, reduced functionality, and fewer innovative tools designed to meet their financial needs. Congress has a responsibility to check executive overreach, especially when it's done through a rushed, opaque, and politicized process that results in less innovation and growth and worse consumer outcomes. This resolution gives us the opportunity to do just that. I urge the committee to support these resolutions of disapproval, and I yield back.
Thank you very much, Mr. Barr. Ms. Waters, you're recognized for 5 minutes.
Thank you very much, Chairwoman Fox, Ranking Member McGovern, and members of the committee. I wish I was here to testify under different circumstances, but where we might be discussing about legislation.
Ms. Waters, will you pull the mic close
Thank
to
you.
you? Okay, thank you.
I'll start again. Thank you, Chairwoman Fox, Ranking Member McGovern, and members of the committee. I wish I was here to testify under different circumstances where we might be discussing bipartisan legislation to lower prices for consumers or strengthen consumer protections or even fulfilling our duties under the Constitution to conduct meaningful oversight of the Trump-Musk regime. But no, House Republicans have turned a blind eye while the regime usurps Congress's power and unlawfully tries to delete the Consumer Financial Protection Bureau. I'd like to remind the panel that the CFPB is the only federal watchdog consumers have solely focused on protecting them from predatory lenders and big tech encroachment in the financial marketplace. Today, House Republicans add insult to inquiry by proposing to advance two harmful and anti-consumer pieces of legislation. The first bill is S.J. Res. 18, a partisan Congressional Review Act resolution that will increase bank fees. You heard me right. I said increase bank fees, and it will impact 23 million households, or roughly 1 in 5 households that incur overdraft fees each year. Many of these fees are $35 or $40, even if you briefly overdraw your account a few dollars. Let's clear up a few myths. CFPB's rule does not ban overdraft fees, but rather it sets a reasonable limit at $5 per overdraft charge by the biggest banks. Despite what opponents may claim, the rule does not impose a hard cap on these fees, as it provides flexibility for large banks to charge more if their estimated costs and losses in providing the service are higher than $5. The rule even allows big banks to charge even higher fees if they provide a simple upfront cost disclosure to consumers. That's right. The biggest banks can charge higher fees, but they just have to tell consumers that they plan to do so. Furthermore, this rule does not apply to any small community banks or credit unions. In fact, 97% of all banks and virtually all credit unions are completely exempt from the rule. Now, Republicans will try reverse psychology and claim rescinding the overdraft rule will somehow result in better banking service and lower fees for consumers. If that were true, then why do nearly 300 consumer, civil rights, labor, religious, and community groups across the country strongly oppose this bill? Last Friday, we got a new report that a key Federal Reserve metric of inflation is going up, which sent the stock market further into the tank. Whether you like the CFPB or not, it doesn't make any sense to hike bank fees on 23 million hardworking families. Why do you want to force them to pay $5 billion in more fees every year? The second bill is S.J. Reg. 28, another partisan Congressional Review Act resolution that will prevent the CFPB from supervising payment apps offered by big tech firms, including Apple, Google, and Elon Musk's X app that will soon get into the payments business. Normally, the CFPB examines the largest banks along with the payment apps and services these banks provide consumers. CFPB checks to make sure they're complying with applicable consumer protection laws. CFPB's payment apps supervision rule simply levels the playing field for banks. That is because big tech and other non-bank firms have increasingly offered mobile wallets and payment apps for consumers to use. The same consumer protection laws apply to them, and Congress gave CFPB the authority to examine the largest participants to ensure they are complying with those laws. So let's be clear. CFPB's rule that S.J. Res. 28 would repeal imposes no new consumer protection standards on these large payment apps. It simply allows CFPB to check if they're following current law. This is important because I've received more and more complaints from constituents who have been tricked, scammed, and defrauded out of their hard-earned money on these payment apps. Candidly, we should be working together to tackle this rise in payment fraud. Unlike the overdraft bill I first discussed, H.J. Res. 28 was never considered by the committee. We have a markup on Wednesday and could easily have considered it there. Why are Republicans in such a rush to pass this? I know that Trump recently turned the White House lawn into a Tesla sales lot after Tesla's stock tanked. Maybe the president is ordering this bill to be passed now so Elon can launch his payment app without any supervision and recoup the money he's lost after Americans have resoundingly rejected Musk's reckless Doge work, including unlawfully firing CFPB employees. Madam Chair, our constituents are deeply concerned about losing their Social Security and Medicaid checks because of the reckless government cuts. They are concerned about how Elon Musk is using his government role to further enrich himself. At the same time, families and businesses are struggling as Trump's chaotic and dumb tariff wars raised costs across the board. It makes no sense to pass legislation that increases bank fees and eliminates oversight of big tech apps, while millions of people are being defrauded, scammed, and ripped off. In fact, the only thing bipartisan about both bills is the opposition they both received in the Senate. It is not too late to turn back. I urge members of this committee to show some courage, stand up for consumers, and reject these harmful pieces of legislation. Thank you, and I look forward to some questions.
Thank you, Ms. Waters. Representative Barr, I'm not sure if I've seen as many rules as concerning as the one with respect to the CFPB's rule on digital wallets. Can you elaborate on the justification the CFPB made when deciding to regulate this space and create such an unnecessary rule?
Well, thank you for the question, Chairwoman. The Dodd-Frank law ostensibly authorizes this rule, and this is multiple iterations of this rule. Thank you. But the real problem with the larger participant rule that was a midnight rulemaking from former Director Chopra is that it is a one-size-fits-all approach, and it's not tailored to the various different types of products for larger participants for all these various financial technologies. So they don't really take a look at the granular specific risks of a particular product. They don't look at the differences between these digital wallets and different payment applications. And as a result, they lump everything together right now, which will stifle innovation. And they subject these participants to supervision, which again is overbroad, and it would extend the supervisory reach of the Bureau way beyond the original purpose.
Well, you know, I read my mail and I answer my mail, and I don't know how many hundreds of thousands of letters I've gotten in my time here. I don't believe I've ever gotten a letter complaining about one of these entities. I just don't believe I've ever gotten a letter. So it seems to me that this was a solution in search of a problem.
Exactly right. And not only does that corroborate that your experience from your constituents corroborates what the Bureau itself is receiving. Less than 1% of all of its complaints relate to these products.
Okay, thank you very much. So now to the rule on overdraft fees. Is it not the case that overdraft revenues in the banking sector have actually decreased in recent years, even as overdrafts themselves seem to have remained more or less constant?
They have, and that just goes to show, Chairwoman, that competition and choice, not central planning from Director Chopra, is what constitutes true consumer protection. When you have robust competition where consumers can shop with their feet, if they don't like a particular overdraft service, and by the way, it's a convenience. They can opt in or they can opt out. It is not a product that is crammed down their throats. They can choose not to have this service. They can opt out of it. They can also shop on what an overdraft fee looks like from this institution versus this credit union, from a big bank to a small bank. But here's the reality, the marketplace reality about overdraft. Larger banks can afford the cap that the Bureau is putting into place. They can afford it. You know who can't afford it? The community financial institutions, the credit unions. They can't afford to provide this convenient service without some level of compensation for the convenience that they're offering to someone who doesn't want to be embarrassed at the point of sale. And their consumers want this service. They know exactly what they're getting, and they choose it in lieu of a more usurious product like a payday loan. And the irony is that the CFPB and our colleagues on the other side of the aisle apparently want to push these paycheck-to-paycheck Americans into higher cost, higher risk products.
Thank you very much. Mr. McGovern, you're recognized.
Yeah, thank you, Madam Chair. I kind of feel like we've entered the twilight zone. I mean, this bill raises bank fees. I mean, Republicans are raising bank fees on regular Americans. It is that simple. I dare you to do a town hall in person where you go before the audience and stand up for banks over consumers and argue that somehow the banks are the victims here, that they're not, the poor banks, and then say, oh, people have all this choice. I mean, people's lives are busy. They're complicated. Not everybody has financial advisors to guide them. But the idea that somehow we're here to say that, it's okay to raise bank fees on regular consumers, I think is absurd. I mean, that's what this is about. And I get it. I'm sure, with the change in leadership, the banking industry came in and is, making all kinds of requests. But I got to tell you, if I ever got up before an audience in my district and made the argument that you just made, I mean, I'd be booed out of the hall. I don't get it. Ranking Member Waters, I didn't know if you wanted to add anything to anything that's been said, but I wanted to give you the opportunity now.
Thank you, Mr. McGovern. I'm overwhelmed with the fact that we have elected officials supposedly representing their constituents who seem to put a lot of time and effort into making sure the big banks can do whatever they want to do, charge whatever they want to charge in fees, and somehow claim it's the constituents' fault that they're not shopping around enough. They're not smart enough to know that maybe they have some alternatives. But, of course, I guess they expect their representatives to know, and they expect their representatives to represent them. But, it's disgusting to have to deal with an issue like this when, in fact, again, the big banks, the biggest corporations in America, have the opportunity to be represented in this way while they refer to people living paycheck to paycheck, but they're not willing to help the people living paycheck to paycheck. It's a lot I could say, but what the hell?
No, I appreciate that. I just, this whole Rules Committee meeting has been really troublesome. I mean, we're taking up a bill that's making it more difficult for women in this country to be able to register to vote. And everybody's behaving like, oh, it's no big deal. You'll go get a passport, $160. Making it more difficult for people in the military to vote. And on top of all that, I can't quite understand why we're even talking about that issue, because we already had a rule to bring it up. But apparently we're bringing the SAVE Act up in order to be able to provide cover for Republicans who are going to vote to make it impossible for a new mother to be able to vote by proxy. So much for a family-friendly Congress. And then this, again, a bill that will increase bank fees on consumers. My constituents don't want that. So that's where I am. Do you want to add? You could.
Well, just to clarify, it's this is not increasing bank fees. The fees are coming down in the marketplace. It is absolutely incorrect to characterize this resolution of disapproval as increasing bank fees. The opposite is true. And with respect to the ranking member's characterization of the intelligence of it's precisely because our consumers are smart that they want this. They recognize that the convenience of a fee to pay an overdraft charge to avoid the inconvenience at the point of sale as a liquidity bridge when they've run out of cash in their account is better and less expensive than a high-cost payday loan.
Well, I would just say sell that someplace else. It won't work with my constituents. And this is about raising bank fees. Let me read you. I don't ever agree with anything this woman ever says, Laura Loomer, but she tweeted, yes, really, hopefully you can put an end to this, Elon Musk. The GOP doesn't like CFPB. And so they are now just opposing everything CFP has done, including the good things like implementing a law in 2024 that banned payment platforms like PayPal, Stripe, and Venmo from banning people based off their political affiliation. Senate GOP just voted to legalize debanking. They should kill the companion bill off in the House. I mean, we just have a very different viewpoint here. But I'm going to tell you, my constituents don't trust big banks. And because they've been screwed by big banks time and time and time again over the years. And I'll tell you, I guarantee you, if you get your way on this, they're going to get screwed again. So,
Mr. Gentleman would yield. I just want to make sure we get this on the record and everybody understand. Community banks are not subject to the rule, and 97% of banks are exempt from the rule. That should be understood by everybody.
I appreciate it. Thank you.
Well, if I could respond to that, the reality of the way the rule works is that if you cap it for the big banks, guess what? Guess who's in competition with the big banks? Community banks. What we want are community banks to be able to compete with larger banks, regionals and big banks. We want them to be able to compete with them, to provide similar services and products as the big banks. If you cap the fees for the big banks and create price controls for the big banks, who can afford them? Guess who gets hurt? It's the community banks who no longer can offer this service to their customers, a service that is in demand, safe, and is transparent.
Well, I'll end as I began. I dare you to go before an in-person town hall and give the same speech you just gave right here, because it won't go over very well. People understand what this is about. It's about raising bank fees on regular consumers, and people want no part of it. Thank you. I yield back.
Thank you, Mr. McGovern. Mr. Barr, thank you very much for correcting the record that this does not raise bank fees. I think we are going to have to state the truth every time.
Madam Chair, I am stating the truth. This will raise bank fees, with all due respect. So I will correct the record as well.
And the lady you quoted said it was implementing a bill. It's a rule, a regulation, and that's part of the problems with people who make these comments. Mr. Langworthy.
Thank you, Madam Chair. Representative Barr, regarding the CFPB's overdraft cap rule, what steps had financial institutions already taken and continue to take to promote transparency and flexibility in their overdraft products for consumers?
Well, I think the first thing you have to understand is that the law already requires that this is a voluntary product. And when a bank opens up a checking account for a customer, they give that customer a choice. And that choice is, do you want overdraft protection or do you not? In other words, if you've run out of money in your bank account and you go and use your debit card at a point of sale and your purchase accidentally is over the amount that's the balance that's left in your account, do you want the bank to cover that, provide the convenience, avoid the embarrassment of a rejection at the point of sale, protect that individual potentially from criminal liability by covering that and providing that short-term liquidity? And if so, here is what the fee is associated with that. these customers know what that is. They know what that is. They use it. They use it sometimes repeatedly because it's less expensive and more convenient for them to use that on a paycheck-to-paycheck basis than to resort to the inconvenience and the cost and the higher cost of going to a loan shark or a payday lender. This is one of the most popular products that banks and credit unions offer to their customers, and the low complaint levels bear that out.
Well, thank you for clarifying that. And turning to the CFPB's larger participant rule, can you remind us again, is CFPB leading the way in supervising these electronic payment companies, or does such supervision already exist?
Well, I mean, the supervision already exists. The problem is that they're trying to broaden and expand their supervisory reach, and they're trying to do it in a way that lumps all of these very different, divergent types of payment platforms into one basic standard, and that would stifle innovation.
And will these controls, rules, and these regulations issued in the Biden rule via CFPB, both before us today and beyond, ultimately restrict what is financially available to everyday Americans?
It would absolutely have the effect of restricting access to these products, and in particular with respect to the overdraft product. The overdraft product, in many cases, will go away, and Americans will lose access to that short-term liquidity.
Well, thank you, Representative Barr. I look forward to supporting these measures on the floor, and I yield back, Madam Chair.
Thank you, Mr. Langworthy. Ms. Scanlon, you're recognized.
Thank you. Representative Waters, am I correct that the regulation we're talking about here caps overdraft fees charged by big banks?
Yes.
Okay. So this regulation, if we overturn it with this CRA, would allow the country's biggest banks to charge even higher overdraft fees.
Yes.
So our Republican colleagues want to make sure that big banks can price gouge even more from American consumers.
Absolutely.
At least they're on brand. We heard a little bit of testimony that consumers opt into these overdraft fees. Have you ever known a big bank to negotiate with a non-commercial client to negotiate overdraft fees?
No, as a matter of fact, I don't know exactly how they supposedly disclose this, but I bet you they don't tell them what it's going to cost them in order to, take advantage of this service. And while we're looking at, possibly $35, $40, et cetera, and we're trying to cap that, I bet they don't tell them that.
It's probably in the same fine print as the forced arbitration clause. It's really disturbing. We've seen some really good work come out of the CFPB, saving money for consumers, cracking down on some of these predatory practices, and to see this attempt to roll back even more, even as this administration is moving to gut the Consumer Financial Protection Board. It's really disturbing because the biggest winners in this are going to be the corporations that profit off deception and fraud. I don't think these two resolutions have much to do with reducing regulation. It's about taking power away from consumers. Just more generally on the rule, our colleagues across the aisle are really famous for having themes, legislative themes each week. Some weeks it's veterans, other weeks it's education. For most of the last year or so, it's been protecting the rights of household appliances almost every week. So it's the last day of Women's History Month. So it should be expected that we'll be dealing with a rule to advance bills regarding women's rights. And we are, except it's about limiting women's rights. So in this bill, in this rule that we're considering today, we're considering the SAVE Act, which makes it harder for women to register to vote, disproportionately harder. And the rule itself is going to manipulate the rules of the House in order to prevent a vote on a bill that would make it possible for new mothers to vote. So happy Women's History Month, and I yield back.
Wow, thank you.
Thank you, Ms. Scanlon. That begs for a lot of response, but I am going to control myself tonight and not respond to what should be responded to. Mr. Griffith, you are recognized.
Thank you so much, Madam Chair. You know, this is an issue that I think, when you actually understand the law, should get all of my Democrat colleagues supporting the resolution to disallow the rule on the bank fee for insufficient funds. Senate Joint Resolution 18. Let me explain why, because I want y'all to pay attention to this, because while it may have been well intended by the CFPB, they're not criminal lawyers. They don't understand the criminal law. And guess what happens to the small consumer in this country when we don't get rid of this rule? The banks and the credit unions go away from having the program where you have the insufficient funds. I've used it. You sign up for it, and the bank will mark, or the credit union will mark on that check or on that withdrawal, insufficient funds. In the Commonwealth of Virginia, where I practiced for nearly 30 years, I've represented a lot of clients in this situation. Because what happens when you have insufficient funds marked on there creates a presumption that you're attempting to defraud the merchant. Now, this only applies to merchant expenses. But you're defrauding the merchant. It is a Class 1 misdemeanor carrying up to 12 months in jail and or a fine up to $1,000 or $2,500. I think they raised it to $2,500 since I quit practicing, but it was $1,000 when I practiced law. It was up to 12 months. If it's over $1,000, it's considered a felony, carrying up to 5 years in the penitentiary. So here we are arguing that somehow we're letting banks, take advantage of small consumers, when in fact the banks are protecting them from potential, as long as they're not truly involved in a criminal scheme. It prevents them from having an insufficient fund returned to the merchant. And guess what happens under the law in Virginia? You get to charge at least a $50 fee. There's some other, they've added some new stuff on that goes above that. I'm not sure I understand that. But the merchant gets to charge a $50 fee that the CFPB doesn't have any control over, and this rule doesn't deal with. The merchant gets to charge that fee. And if it actually ends up where there's a criminal charge, and that happens on a regular basis, or happened on a regular basis in the past, even if you pay the check off, you have to pay the $50 merchant fee, and you have to pay the court costs, far in excess of the average of $35 that some of these institutions have been charging. So I grant you, I understand the frustration. I don't care about the big banks so much, but I do care about the clients that I represented, because I represented the little guys in a Main Street practice. And what you all are inadvertently doing by not supporting this resolution is hurting the little guys, because they're going to end up facing criminal penalties or criminal charges at the very least, with higher fees than what the bank is charging. I think it's bad policy. And I believe there's similar laws in the Commonwealth of Kentucky. Is that not true?
That is true. In fact, Kentucky Revised Statute 514040 is the theft by deception statute. And not only is the merchant entitled to charge a $50 fee, which is more than what the bank would or the credit union would charge for overdraft protection, but then theft by deception is a Class B misdemeanor at the lower scale. It can be a Class A, it can be a Class B, depending on the amount of the overdrawn check that would create a theft by deception charge by the county attorney. And if it's a very large check, it could even be a Class D felony. So this could carry actual jail time. What the banks and the financial institutions are providing is protection. It's protection for the consumer. And this is a very important point that the gentleman from Virginia is pointing out. Virginia obviously has similar criminal statutes as Kentucky.
Yeah, I'll just tell you, I'm very glad this protection has been there. My wife gives me a certain amount of money in my account. She gets all the money in our household, and she gives me a certain amount of money on the credit union up here, our federal credit union here. And there have been months when she has chastised me and said, when you just use that card willy-nilly, they charge you a fee when you run out of money. And I said, they do? And she said, yeah. But I'd much rather have that than to have somebody saying, no, you can't buy that meal on the way home because your money's run out, or thinking that I'm attempting to defraud them. So this is where these fees were originally came in to be very popular, is because people do opt in, because people do like them, because if you're inadvertent, it's a way of saying to whomever you're spending that money with, I'm not trying to defraud you. And the state recognizes that as better than having something returned for insufficient funds and potential criminal penalties. Mr. Barr.
Yeah, and if I could just respond to the gentlelady's point that this is Women's History Month. I have a constituent, and the gentleman from Massachusetts talks about our constituents and whether they want this or not, and the town hall scenario. Let me just share my constituent, a female constituent, and her testimonial about this product. And this was told by a financial institution. We have a customer with 2 children in Versailles, Kentucky, and her husband is in the military. As you know, things can be difficult when one parent is deployed and one parent is alone with the children trying to manage finances, school, after-school activities, and church. As the customer said, things can be overwhelming, even exclusive of her husband's deployment. The customer approached me in church with her head down, saying that she was having a tough time with things. Some expenses surprised her, and she was suddenly out of money for the month. She was okay, as she had groceries, gas, and her bills were paid until she got a flat tire on the way to a school function. She got the car to the tire shop, and the tire was irreparable. She had to buy a new tire for a couple $100 she didn't have. She was not able to keep up with her car, so she had to buy the new tire. There was no choice. She ran her debit card, and to her surprise, it covered the tire. She ran the debit card. She didn't have the money in her account, but it covered it. It covered the tire. And she said she got home, and she checked the account when she got home, wondering how it was paid for, because she knew she didn't have the money for it. And it was her overdraft that covered it. She thanked me that her community bank was there for her to cover her overdraft so she could keep moving without having to call for help. Needless to say, I was tremendously humbled that we could help this mother whose husband was deployed in the military due to the overdraft, and I was grateful we were there to cover it in time of need. That is a celebration in Women's History Month, that overdraft protection protected that female mother of 2 with a deployed husband.
The gentleman yield for one second.
I appreciate it, but I'm not going to yield. I yield back.
That's typical.
Thank you, Mr. Jack. You're recognized.
No questions, Madam. Thank you.
Thank you. I see no other members wishing to ask questions, and so I thank our panel members for being here. Thank you.
Anyone with an amendment?
I believe we have at least one member who wishes to offer an amendment.
Yeah, we're done. Good job.
Ms. Johnson?
Yes, ma'am.
Texas?
Yes, ma'am.
We welcome you to the Rules Committee. I'm not sure how long you've been there because we've had a crowd, but I hope that it's been a good experience for you. Is this your first time?
It is. It reminds me of the Texas legislature. This is how we do all the hearings down there, a little back and forth and little member questions. It's good. It's an honor to be here. Thank you.
Well, if you've heard my comments, we welcome your written testimony, and we hope that you can keep your spoken comments to 5 minutes.
Yes, ma'am.
Thank you.
Thank you. Thank you so much, Madam Chairwoman. I come here today as a member of the Subcommittee on Elections and House Administrations Committee, and because voting and the right of the people to select their leaders are among the most sacred rights that we must always defend. I appreciate the efforts to ensure that our elections are safe and free from foreign interference and that only U.S. citizens are allowed to vote. However, this bill seeks some solutions for problems that don't exist, and it creates some other problems that I'm very, very concerned about, of which I've offered 3 amendments that I hope the committee will substantially consider. one of the big concerns is that we don't allow for any mail or online voter registration in this new version. We have many states that allow for that, but we also have many service members, persons with disabilities, seniors who rely on online and mail-in registration in order to register to vote. This bill requires allows for only an in-person voter registration. So my amendment would allow for people to provide their documents online, to be able to take care of folks who are not able to get out of their homes. Because as this bill is written, it will absolutely deny the right to register to vote for eligible citizens. And I would think that that is something that every member of this committee would be very concerned about, like I am. My second amendment provides teeth for those who are wrongfully denied the right to vote, who are eligible. Can you imagine being a citizen of this country and you put in your voter registration and somebody tells you you can't vote? How are you going to respond to that constituent that reaches out to you that says, I was denied the right to vote and I'm legally entitled to? We have to take an abundance of careful measures to make sure that those are allowed to vote. And so one of my amendments gives a right to cure. If you've been denied the right to vote, then you should be able to have a district court have a hearing on your denial within 24 hours to determine if you have been wrongfully disenfranchised the right to vote. Because we, as the Congress of the United States, should seek to ensure, without waiver, without hesitation, without question, every eligible citizen of this country should be able to vote. And then thirdly, we have a lot of provisions in this bill that require for criminal penalties for those on election administrators who register in illegal aliens to vote. Well, likewise, if they wrongfully deny the right to vote of eligible citizens, then criminal penalties should ensue likewise. So they can't have on the one side and not the other. If there's going to be criminal penalties for them doing their job, then it needs to also ensure that legal citizens have the right for recourse in the event that they are wrongfully denied. And those people are held accountable if they seek to intentionally deny the right to vote to legal citizens of this country. So those are my three amendments. I deeply hope that the committee will seek to improve this legislation to make sure that Congress does its constitutional duty to make sure that we protect the inviolate right of every person in this country to vote if they are able. Thank you, Madam Chairman.
Well, I thank you very much, Ms. Johnson, for your comments and for your amendments. Mr. McGovern, I have no questions. Mr. McGovern.
Yeah, no, I would, first of all, thank you for coming here. Thank you for your patience. I support all three of your amendments. They all are reasonable and thoughtful, which probably means they won't be made in order. I sometimes have jokingly that the Rules Committee is the place where democracy goes to die sometimes. And on a bill regarding voting rights, I mean, and voter protection, I really do think we ought to open it up and allow some different points of view to be put forward. So we support your amendments. We will, if they're not made in order, we will absolutely, tomorrow when we meet to report out the rule, I will offer them, and hopefully we'll get be able to get some Republicans to vote for it. I will also just take my moment here to say that, again, as you can see, we're outnumbered here, 9-4, and so sometimes, and I always regret when we don't have an opportunity for a give and take or debate. But I just do want to say to the gentleman, to suggest that the CFPB rule somehow benefits big banks, I find that to be over the top. Even Senator Josh Hawley, who I can't even agree on what to have lunch with him about, opposed this resolution on the Senate floor, and he knows this resolution is harmful, telling reporters, and I quote, "Why would we help the big banks at the expense of working people? I just don't understand it." I mean, there is a consensus, a growing consensus with Democrats and some Republicans, with liberals and some conservatives, that what Mr. Barr is bringing before this committee will be harmful to regular consumers, our constituents. So I just wanted to say that because I have a little moment to be able to express myself. But I support your amendments. And again, this so-called SAVE Act, I think disadvantages women in particular in a way that, again, I hope it doesn't become law, but if it ever does, it's like a poll tax.
Well, that's right. I mean, one of the biggest problems, though, is for married women, if look, they could get it wrong. Well, where's the right to fix it? There's no right to fix an error in this bill. Nowhere do all the 80 million married women across this country have a chance to say, this clerk got it wrong. I'm a citizen, I deserve the right to vote, and I demand my right to vote. And we, as Congress, have an obligation to ensure that every citizen of this country is able to vote in our elections. And unfortunately, this bill has way too many problems with it that will rid and deny people the most violent thing that we have in this country is the right of self-determination and the right to vote. It's what distinguishes our democracy from those all across the world, right here. It's what we were founded on. And so I think these amendments really go to cure a lot of the problems that could really prohibit people having their right to vote. I know if I was denied my right to vote, I'd be damn mad. Yeah. And I'm sure a lot of people, everyone in this room would as well. Yeah. And what recourses do we have under this bill?
Absolutely.
Nothing.
And again, the ability to, comply with all that you need to comply with to prove that, in fact, you are who you say you are could be costly. Maybe it doesn't matter for Elon Musk. He doesn't care about money. He gives out $1 million checks, right before elections to try to, persuade, buy votes. But, $160 for a passport for a lot of people is not only a lot of money, but the time it takes to get a passport, may prevent you from being able to register in time. So anyway, I will support your amendments. I thank you for being here, and I yield back.
Thank you.
Thank you, Mr. McGovern. Mr. Langworthy? Ms. Scanlon?
Yeah, I just wanted to thank you for bringing these amendments. I think we hadn't devoted much time yet in this debate to the fact that this bill would disenfranchise folks who are serving overseas, folks with disabilities who are unable to meet the in-person requirements. So I think that's a really important amendment, as are the ones that provide some balance here, because the whole weight of this bill is to disenfranchise eligible voters in order to solve this non-existent problem regarding non-citizen voters. So I think the cure provision, the fact that there would be balancing criminal provisions all make a lot of sense, and I will support those amendments. Thank you.
Thank you. It's interesting because I don't know how you can say you support our veterans and not support my amendment. Because how in the world are they supposed to come in person when their kid turns 18 or whatever? How are they supposed to register to vote if they can't do it online or remotely? How can you support seniors who have mobility problems, who can't, maybe they don't have a driver's license anymore, or whatever? How can you support people with disabilities and not give them an opportunity to vote when there's absolutely no reason why they can't submit a passport online, submit their birth certificate online? There's absolutely no reason at all. We submit electronic documents to prove who we are all the time. And so other than to keep people from being able to exercise their constitutional right to vote, and I really do think that this amendment needs to be strongly considered.
I appreciate it. Thank you. I yield back.
Thank you, Ms. Scanlon. Mr. Griffith?
No question.
Mr. Jack?
No question.
Thank you. Thank you, Ms. Johnson. You're
Thank you so much for the
excused.
opportunity to be here. I hope you strongly consider my amendments.
Do we have anyone else seeking to testify on H.R. 1526, H.R. 22, S.J. Res. 18, or S.J. Res. 228? Seeing none, this closes the hearing portion of our meeting. and the committee stands in recess until 8 a.m. tomorrow morning.